Yeah, this is very much an overview for those of you who are practicing lawyers. Of course, this is old hat, and for those of you who are engineers or not lawyers, you will probably find it pretty bewildering, which is pretty much the way that I come into it as well. Overview. Workers' compensation is the exclusive remedy that an injured worker has against his or her employer. The problem with workers' compensation is that it pretty well covers the direct costs that an injured worker incurs, principally medical, but does not adequately deal with loss of income or pain and suffering, so that for pretty severe injuries, workers' compensation is really not an adequate remedy. Beyond workers' compensation, both at common law and through statute, the injured worker has remedies against other players in the construction process: the owner, the construction manager, the general contractor, other contractors, so forth. The particular focus of today's program is around Labor Law Section 240, which, as Debbie mentioned, is known as the Scaffold Law, which imposes strict liability on owners and general contractors for construction worker accidents. And in this context, strict liability means that the defendant, the owner, the general contractor, has no defense available to it for what's known as contributory negligence, which means that negligence of the worker who was injured, who contributed to his or her injury. Now, this Section 240 carves out particular types of construction accidents for this special sort of treatment. And this is accidents occurring due to elevation or gravity-related risks, such as a worker falling and injuring him or herself while working at a height, or an object falling on a worker, injuring that worker. The exception to the no defense of contributory negligence is where the worker is the, quote, sole proximate cause of his or her injury, meaning in contributory negligence terms, 100% of the accident is attributable to the negligence of the worker. Now, there is proposed legislation to modify Labor Law 240 to allow a defense of the injured worker's contributory negligence. It's relatively simple in concept. It's relatively simple to articulate in a statute, and it has kind of the beauty of it is its simplicity in dealing with what amounts to a very complex problem. There are numerous proponents of this statutory change and numerous opponents. And what we'd like to do is kind of summarize for you the pros and the cons, the positions or the arguments of both the proponents and the opponents. The proponents are largely members of the construction industry as well as insurers. The opponents are largely trial lawyers and labor organizations. So on the proponent side, they argue that a number of other states had what you call scaffolding laws. They were enacted in the early to mid-1900s, and they had this particular feature of not permitting the defense of contributory negligence. All of those states, save New York, have changed the standard, and have changed the standard to that which is set forth in the proposed legislation. And the statistics that the proponents advance is that insurance rates for construction insurance have decreased significantly, and interestingly, likewise, accidents from gravity related from heights have decreased.
Today we're going to be seeing a lot of data, both supporting this position and perhaps not supporting this position. What kind of critical questions should we be considering when looking at that data today?
Well, of course, that question is one of the major questions raised by the opponents. You're going to see some great-looking PowerPoints and beautiful colors and graphs and charts purporting to represent data related to this issue. The issue is, where does that data come from, and to what extent is that available to scholars, to researchers, to independently analyze? As it turns out, at least the proponents or the opponents of the legislation claim that most of that data comes from the insurance companies themselves, who do not release the underlying data from their records on the grounds of confidentiality and it's a highly competitive industry. And so the opponents argue that the insurance companies are, just trust us, this is the straight information. But we suggest that as you listen to both proponents and opponents, keep in the back of your mind and maybe impertinently raise your hand and ask, where's the beef? Where's the data? Who has had access to this data? Where did it come from? It's a major issue, and in fact, there is proposed legislation in New York to require insurance companies to provide that data so that it's not a situation of just trust me, it's all real. Now, other arguments of the proponents is that it's really unfair to everyone to permit a system that doesn't impose any responsibility on the injured worker. The proponents argue that there's a lot of alcohol and drug-related construction accidents caused by the worker's failure to pay attention to instructions that are given by the employer, failure to use safety devices properly that are either provided or made available to the worker, and that all society is bearing the effect of kind of giving injured workers who were injured because of alcohol, drug-related, and so forth, a free ride. If the proponents argue that if we change Section 240, we're going to reduce significantly insurance costs and thereby free up money for needed construction and needed infrastructure and new schools and highways and bridge rehab and whatnot, and that that's very important societally, and therefore we should compensate injured workers fairly for accidents to the extent not caused by the construction worker, but we shouldn't subsidize things like alcohol and drug-related caused injuries.
You talk about the fact that the proponents are saying that if we amend 240, insurance costs will go down, and that data in comparative states have proven that. Maybe it's a good opportunity to talk about the opponent's point of view, but is there reason to think that insurance rates are higher in New York State specifically because of specific things happening in New York State?
Well, again, the statistics that you're going to see purport to show that insurance, construction insurance, whenever we say insurance, we're talking construction insurance, rates are significantly higher in New York. Proponents of this proposed legislation attribute this, at least in significant part, to Section 240 and its not permitting the defense of contributory negligence. The opponents seriously question that. Is it because in New York we have a greater proportion of complex, sophisticated construction that is riskier and has a higher incidence of accidents? Is it because the cost of medical treatment in New York may be significantly higher? Is the money all going out to, God forbid, lawyers who handle these types of cases? So, again, where does the money go? And when you try to, I don't like the expression, but drill down, you find that most of that data is in the hands of the insurance companies, whom the opponents of the legislation say are withholding that information, and therefore it's very difficult to make an informed judgment about these issues.
So perhaps talk to us more about the other positions of the other
Well,
components.
other points raised by the opponents is that, first, elevation-related accidents tend to be the most serious, cause the most serious injuries or death, and the contention is that these are the easiest to prevent or control, and that such prevention or control must start at the top and work its way down. And so the way to facilitate this is to have strict liability against the owners and general contractors who are in the best position to reduce or prevent elevation-related injuries, and therefore it represents good social policy to have a statute that provides the greatest incentives to owners and general contractors to prevent accidents on their watch. Second argument is, well, you know, you talk about workers who are injured because of alcohol, drugs, and so forth. The opponents say the greater part, by far, of worker injuries, particularly from elevations, occurs through no significant fault of the injured party. And by changing the standard in Section 240, what you're doing is you are slowing down, making more difficult, more protracted, more costly, I'm going to call it legitimately injured, in the sense that the worker has not significantly contributed to the injury. Workers will be delayed and their recovery significantly reduced by legal fees, while the comparative fault issue is fought out in courts. And whereas the injured workers and their families do receive the benefits of workers' compensation, in many instances the injuries are so serious that the worker is really not able to productively work again, and the injured workers and their families have to wait years to get recovery. Another point raised by the opponents is that when comparisons are made between statutory changes in other jurisdictions and try to project those results to New York, that the legislation and legislative and common law scheme in other states differs from New York, and the comparisons aren't fair. They're not apples to apples comparisons.
You had just talked about one example, which was the worker who deserved compensation and that it wasn't their fault. And I think one of the thought processes behind that is that why would a worker endanger themselves? Why would a worker go up onto a high place in a compromised position? And it seems that this suggests that some of the conclusions that when you reached by the data of the proponents, when you remove this law of strict liability, it becomes safer implies that perhaps the
Something
workers
else.
themselves are
Yes.
now, oh, now I can't receive a lot of money. Now I'm going to start being more safe. It was the loss of the monetary incentive as opposed to their own safety that was motivating them. Can you
Well,
talk about the data concern?
and this is again another point of the opponents that there appears to be, and I say appears again because of the lack of access to good data, there appears to be a significant problem of false, fabricated, and inflated claims by construction workers, particularly those nearing retirement age, that if they can put through and recover on a good claim, this will be part of their retirement income, and that the proposed legislation does not address this issue at all, and they contend that this is a significant part of the increased cost that you were talking about earlier, Debbie.
It seems that when we talk about proponents, we're talking about proponents who would like to change the situation by directly amending the bill. And when we talk about opponents to this position, there's really two camps. One who supports the imposition of strict liability and would like to keep things how it is, and another camp who doesn't support the imposition of strict liability but doesn't see a bill amendment as the best way to accomplish the goals of increasing worker safety and of reducing insurance costs. So now that we've seen, I guess, these three positions, you could call it, what kind of conclusions could we think about or reach after
sitting through today and listening to everything and weighing it all? There are more than three possible conclusions that you can draw, but Debbie and I have come up with three for your consideration. Number one, enact the proposed change to Section 240 of the labor law exactly as it has been proposed. There is nothing to lose, everything to gain. It's a simple change, and if it doesn't work, it can always be repealed. Another conclusion that you might come to is that, based on everything that you hear, is we really need to engage in further study. We've got to get the underlying data from the insurance companies first in order to understand really what's happening before we start changing the law based upon supposition. And finally, let's not just deal with Section 240 of the labor law. We need a more comprehensive, non-simplistic overhaul of the labor law and the way that construction accidents are handled and compensated for through the legal system. And so maybe you all will take a vote at the end of today which way we ought to go. Thank you.
Thank you so much.
Did you want to take a few questions?
Well, we were thinking that the panels today would be the answers to the question, because this was just.
Yeah, we only ask questions. We don't answer anything.
So you're on time.
Yeah.
Excellent. So thank you. We have scheduled we did a 15-minute break. So, and given the transportation people coming down from Westchester County, we probably should take a few minutes to get a cup of coffee since we did this. So we'll start back up at 9:15. The view from academia.
I thought people were.
Good morning, everyone. I'm Ariel Belen. I'm the moderator of this panel. I'm going to introduce the panelists in a second and give some background as to their areas of expertise and experiences they've had in this field. Before that, I really want to thank Deborah Kirshner and Robert Rubin for the excellent presentation they just did. Elizabeth Koscienda, I don't know if Elizabeth's here, from the City Bar for helping to put the program together. And most of all, and I'm doing this right now, at least I forget, Terry Matthews. Terry has done an enormous job in putting this whole program together from soup to nuts. And so if you leave here today thinking that you learned something and that it was a good experience for you, it really has everything to do with her. So I'm very pleased that I was able to work with her in this effort. Hi. Jeff Grabelski? Yes. Hi. How are you doing? How are you? So, what we're going to discuss over the course of the next hour or so, I'm going to open this up to questions, is from an academic perspective, generally speaking, is the Scaffold Law. Labor Law Section 240, in general Labor Law 200, but in particular 240 Subdivision 1, which imposes absolute liability in gravity-related accidents at work sites when the plaintiff could establish that there was a failure to provide an adequate safety device of one kind or another. Whether that statute makes sense going forward, and whether from an economics perspective, from a safety perspective, from an insurance perspective, things could be improved or should stay the same. On the panel today, to my immediate left is Professor Bentley McLeod from Columbia University. The professor is the Sami Eminmaya Professor of Economics. I did my best with that at Columbia. And he's also a Professor of International and Public Affairs at Columbia. He's a fellow of the Econometric Society, the Society of Labor Economists, and he's done a lot of work in the area of the interface between the law and economics. He holds a bachelor's with distinction and a master's of science in mathematics from the Queen's University in Canada and a PhD in economics from the University of British Columbia in Canada. To my right is Jeff Grabelski, who's an associate director of the Worker Institute at Cornell University. He coordinates the Institute's Strategic Leadership Initiative. He has taught at Cornell and in the New York State AFL-CIO Union Leadership Institute since its founding at Cornell, and coordinates the Construction Career Initiative, a joint project between Cornell University, the Partnership for Working Families, and the Building and Construction Trades Department. He's been a member of the International Brotherhood of Electrical Workers for over 30 years, and is a former national organizing director of the Building and Construction Trades Department of the AFL-CIO. Jeff has a BA in Political Science from the University of Michigan, an MA in Labor History from Syracuse, an MS in Industrial and Labor Relations from Cornell University, and he's a journeyman electrician classification from the IBEW. Next to Professor McLeod is Jacob Arluck. Jacob is an undergraduate research fellow in the Cornell Program in Infrastructure Policy, where he works under Professor Rick Geddes. Their research team is conducting a large-scale study investigating a possible link between public financing types and road quality and safety. He has done work at the Cornell Near Eastern Studies Department, and most importantly, he's been immersed in a study involving the Scaffold Law and a comparative study between New York and other jurisdictions, in particular Illinois, which we will be discussing shortly. Next to Jacob is Bud Griffith, who is a professor of construction engineering and management in the Department of Civil Engineering at Polytechnic University. He's also director of the New York State Resiliency Institute for Storms and Emergency. Bud was the provost, the dean of engineering, and the applied science and vice president for academic affairs at Polytechnic University. He taught and is a professor emeritus in civil engineering at Columbia, where he taught for 15 years, and he headed the construction engineering program and was the director of the Center for Infrastructure Studies at Columbia University. He has 2 master's degrees and a PhD in civil engineering from Oklahoma State University, as well as being a graduate from the United States Military Academy at West Point. Briefly, your speaker is a neutral at JAMS. I'm a mediator and arbitrator there for about 1.5 years. Before that, I was a New York State judge for 18 years, my last 5 on the Appellate Division, 2nd Department. I've, in my time, seen literally hundreds of these cases. I've tried probably, in double digits, if not in 3. Lots of these cases, and I've settled many, many, many over the years. Beginning in my time as an assistant corporation counsel with the City of New York, when I began to defend these cases, I was very intrigued by Labor Law Section 240, Subdivision 1, because it was the only area in my practice that I saw where there was no comparative negligence ascribed to a plaintiff. And so that just jarred me, because it was different. And so today, we're going to engage in a conversation about whether that law makes sense and whether any of the proposed reforms to that law make sense as well. Unfortunately, one of our panelists was Michael Hutter, and he's trapped somewhere around Albany by snow. And it's a shame because he's a professor at Albany Law School. For those of you who practice labor law, you know that he's an authority in the area, and he's written a lot about this, but he just could not get down here today. So I guess I'm going to go between asking the panelists different questions and then also inviting you to ask questions as we go forward. If the panelists, however, had an opportunity to see the proposed questions that we circulated before, you would see that Professor Hutter was going to say that back in 1998 he wrote an article, which is in your materials, wherein he said that the courts really could not be faulted for ascribing an absolute liability standard to 240 Subdivision 1 because it was in tandem with an unmistakable legislative intent to do so. However, he did say that system needed, in sum and substance, needed serious reform back in 1998. And if you read his piece back then, he just seemed, it did not really make sense to him that in this particular sector of litigation, of tort litigation, that a plaintiff could not be held accountable, if you would, or responsible for his or her negligence. He goes on to say, however, that since that time, since then, and since not the abolition, but in different developments in the case law from the rule that was articulated by the Court of Appeals in the case of Koenig, that he feels that the development in this area of the standard of sole proximate causation has really greatly ameliorated the rule, and that basically he thinks that the rule, the state of the law as it is now, with this absolute liability standards, as well as the concomitant ability of a defendant, of an owner, of a contractor to show that if the plaintiff was the sole proximate cause of his accident, and in some variation of that was perhaps a recalcitrant worker, that really the law should more or less stand as it is. He did say, however, that there should be clearer rules for determining liability, and that the courts need greater clarity in this area. So I wish he was here, because I think he would have a whole lot to contribute, but I think I've fairly stated his positions in this area. So I guess my first question is to Professor McLeod. So, and by the way, I assume most people in the audience are lawyers. Is that a fair statement? Or, all right, who's not a lawyer? Okay, all right, all right. And of those who aren't, are you in the industry, in construction? Okay, very well. All right, so Professor, can you tell me, how would you analyze the law from an economic perspective in general, and then more specifically, how do you analyze tort laws from an economic perspective?
Okay, so yeah, well, thank you very much for inviting me here. It's, as I say to my students, the job of an academic is to learn and then tell everybody else what you've learned. So this has been a wonderful experience to learn about the construction industry and this law in particular. I should also point out that as an academic, I have no skin in the game. So this is pro bono. I was asked a couple of years ago to work on this case by one of the industry groups, which I turned down because I felt the data wasn't really quite good enough. And really my job is most of the time saying I don't really know the right answer. So that's what I'll start off with. What I will say, though, which I think is kind of interesting, when you look at there's two steps in the law and economics process. The first step is trying to understand the laws as we see it. And while I don't know the answer, is our judges every day must make a decision whether or not they understand the case. And so what's interesting is that Posner and Calabrese and Coase have sort of developed a way of looking at the law and sort of viewing the rules that we observe today as the result of this sort of trial and error process over basically thousands of years to arrive at a system that works pretty well, right? It's sort of, and what is, I think, particularly surprising, my first work on the construction case was in construction law, and in particular I looked at the AIA form construction contractors and the general contractors contracts, and those contracts, I looked at them, and these were done by people in the industry, and I said, wow, these are amazing contracts. That the first form contracts were done basically at the end of the 19th century. They evolved over about 100 years, and they're pretty good contracts. And so I showed what was the reasoning, what sort of underlying the contracts. Now you also have to remember that the words people use and the economic reasons for something occurring may not necessarily be the same thing. And so in my article, what I showed is many of the clauses in construction contracts made a lot of economic sense, and I argued they were great contracts at the end, hopefully. So what that means, though, it doesn't mean that there's room for improvement. So let me make the next point, which is when I first started working on tort law, it was basically on medical malpractice law. When you first go in, you say, oh, tort law is horrible. But as you begin to read cases by judges, you realize, boy, these guys know what they're talking about. They're thoughtful, and every case they decide, they try to be as careful as they can. And so in my previous research, what we found a couple of things. First, it is true that people seem to respond to the law. So we found some evidence, not huge, but that doctors and participants will adjust their behavior in sort of ways that we expect, in some unexpected ways as well. And I can talk about that if anybody's interested in C-sections and medical malpractice. I can tell you a lot about that, but today we're talking about construction. So then the question is, we're going to move, when I looked at the sort of Law 240, which is a sort of another kind of complicated law, I first went out and thought, well, this is a kind of a crazy complex law. Does it make any sense? And in the memo that's circulated, I said, well, this makes a lot more economic sense than you would think when you first look at it. One of the reasons it's complicated is because essentially over time you have these piecemeal changes, and one change gets topped on the other, trying to solve a sequence of problems. So let's start sort of with basics. What's the fundamental question when we're talking about safety? Essentially, you've got a worker, they have family to feed and to support, and they have accidents. which means that regardless of causation, they have demand for insurance. That is to say, if an accident occurs and they lose income, their family depends on them for income, and so therefore you want to insure them. On the flip side, though, you want to make sure that things are careful. So the other side is, how do you provide the appropriate incentive for everybody to be careful? And so then you have this sort of complex system that basically wants to provide them insurance. And this was sort of the starting of the workers' compensation insurance. But when you brought in workers' compensation, that of course creates additional costs for the employers. And so part of the deal was that employers said, okay, we'll bring in compensation, but we don't want to be held at fault. And so then all of a sudden you broke the relationship between insurance and incentives. And so when we look at Law 240, it's sort of the culmination of trying to solve this incentive problem when we sort of already broke the relationship between effort and insurance way back in workers' comp. Okay? So then a general principle, and so I'm not going to go through all the various details which do the thing, but a general principle of any good rule is somebody's got to be in charge, right? As we saw with the recent Obamacare, which is sort of a disaster when it rolled out, because nobody's in charge. So in a sense, when we see rules like Law 240 and other types of what we call vicarious liability, if you're in a complicated environment, the law tends to try to push liability on one individual. In this particular case, it's going to be the owner. And the reason for that, you want somebody to be in charge and sort of responsible for the overall operation of the work site. Okay, so in a sense, what we are now is that this law, I would say, from a law and economics point of view, we can sort of understand its various forms, but that does not mean it's perfect. And so the next step of law and economics analysis, given the current law, are there directions forward by which we can improve it? And that's sort of the question we want to talk about at the moment. And I guess I have your second question here. I can sort of just roll into your next question, or do you want to?
Well, that's, yeah, so how would you, how would you apply the methodology that you just described in the case of the absolute liability standard of 240? What's your take on that?
Yeah, so again, when you sort of read the New York Times, you get one view of things. I guess I find solace by reading court cases, because when you start reading what judges actually say about it, they sort of make a lot of sense, right? So, for example, in the Blake, they say, it is imperative to recognize that the phrase strict or absolute liability in Labor Law 240 context is different from the use of the term elsewhere. Often the term is liability without fault, as where a person is held automatically liable for causing injury, even though the activity violates no law is carried out without miscase. So, in a sense, the law has sort of two steps. What they mean by absolute liability is once a certain event has occurred, then there's liability. That certain event is some level of care on the work site. Now, one of the things to keep in mind, so the first puzzle I was trying to figure out is why do we have this Law 240, which is different than other areas of tort law? So that was my first part. Well, why is that? Does it make sense? Now, normally when I look at doctors, I look at medical malpractice, you have doctors, they're practicing every day. And they will, in the course of their practice, you're certain patients will die, accidents will occur. So that's a normal part of practice. Now, I was thinking about a worker. Now, workers on a site, they're scaffolding, and they say, okay, I need to do something quickly. I'll remove my harness, do it quickly. Problem is, how often do they get to experiment with doing something dangerous? Not very often, because if they happen to fall off a scaffolding, they're dead. So one of the features that makes death different than other workplace injuries is you can't have trial and error learning. And so that's actually an extremely important point, right? And that's why we regulate death differently than stubbing your fingers and other areas. And so in a sense, again, you say, well, the law is so brilliant. It begins to realize that death is different than day-to-day accidents. And so in some sense it has its own set of regulations. So the first thing to point out is when we're dealing with accidental death and falling from height, since learning is hard, then we can't just allow workers to automatically learn how not to kill themselves, because there's just no learning from. They will make mistakes, no doubt about it. The managers will make mistakes. And then the question is, how do we construct a system which enhances safety, taking into account that one of the parties won't get a second chance? Okay, and so that's sort of the puzzle we're trying to find.
Just to interrupt you very briefly, is that, my take on this has been, and maybe I think this is what you're saying, that the law puts the onus on the owner and the contractor to ensure that the worker is constantly using correct devices to...
Exactly. So the owner, particularly if it's a very large contractor who's dealing with more frequent deaths and accidents on the work site, are in a better position to try and evaluate the cost-benefit analysis. Now, if deaths are relatively infrequent as they are, one of the reasons we're here is often some of these things move to the state level, because the state has a larger database, has more information about accidental deaths, and then is in a situation to ask the question, okay, what sort of safety regulations do we put in place to take into account the cost of safety versus the benefit? And the benefit, of course, right now, we currently value a life at $2 million to $8 million per life. So that's sort of the cost that you're trying to save. And
I
then
like
you
to think I'm more than that, but whatever.
we can argue indefinitely what is the value of a statistical life, but essentially, if we're going to make a decision on cost safety, we can't be perfectly safe. That's unrealistic, but we can't be perfectly unsafe. And so then the issue is how do we move forward? And I'm not really an expert. All I do is I come from the top and I say, look, these are the big issues. And then the question at the bottom is how to construct a system that allows us to figure out what is the sort of appropriate margin. To do this, now one of the things that has come up here several times is the issue of the insurance companies. And I haven't done work directly with insurance companies. I have read a lot of papers that do. As first, it's extremely difficult to get data from insurance companies. I've seen a few papers that do this. Secondly, anybody that's looked at data from insurance companies knows a fact they're not perfect. That is to say, the insurance companies themselves don't even do the best job they can. One of the reasons that is the case is they don't publicize their information. They don't allow competition to occur, and they do that for competitive reasons. Third, there is evidence to suggest that insurance rates and premiums don't seem to follow the actual accident rate. So, for example, doctors that are having more accidents, their malpractice insurance don't seem to move very well. So what I would say is currently the evidence I've seen doesn't suggest that the insurance company seems to be the right locus in terms of trying to bring safety. One area that's well known and has occurred, for example, in medicine. In medicine, we know that the price of a procedure relative to its benefit or its danger is basically this horribly mispriced. So in general, the general economic view, so I'll just give you the general formula that economists always supply, is more information about the environment. So in particular, if we want to have the owner have liability, then they have to have some mechanism by which they can ensure that their contractors are safe. If they don't have direct control over the work site, then they should know, is this contractor safer or less safe than some other contract, and then price that in. If the price of services does not reflect safety, market cannot work in terms of safety.
So, I'm going to come back to this later, but a lot of contracts are done on the basis of purely competitive bidding. Who's the lowest bidder? And there is some, obviously, there's some out, certainly in the public sector, for not hiring a low bidder if they have a bad safety record. But we'll come back to that. So if I could just ask Jacob, sitting next to you now. So Jacob, you participated in a study up at Cornell, which studied the differences among states that have had these types of statutes over time, and I'll allow you to kind of drill down, but in sum and substance, you've compared Illinois, that had a similar statute as New York, and has done away with it. And interestingly, the conclusion you seem to have drawn thus far is that even though New York ostensibly has a greater protective statute, this labor law statute, the incidence of accidents have actually increased over time compared to Illinois, which did away with that statute. So hopefully I haven't oversimplified things, but if you could just speak to the study and some of your conclusions.
Yeah, so first of all, there was a statement made earlier that that a lot of this data is not open source, and in reality, for our injury analysis, it's almost entirely from the Bureau of Labor Statistics. Sometimes we recalculate it because their methodology isn't very good, and we used open source data for that as well. We used employment and hours work data that was from government databases. And I worked on insurance as a topic as well, and that, of course, is not as open source, unfortunately. But the main takeaway from our study, so what we did two types of analysis. First was to do an aggregate safety analysis, look at injury rates, both fatal and non-fatal, because as Bentley says, there's fatal injuries. Well, first of all, fatal injuries are not underreported relative to non-fatal. There's a negative correlation between states that have high non-fatal rates, low non-fatal injury rates and high fatal injury rates. If you look at a state like Texas or anywhere with a lot of undocumented workers, there's going to be a lot more fatalities than you would predict given the non-fatal injury rate. And so what we observed
I just need to interrupt because how many of you understood his point there? Okay. All right. So if you could break it down for us more simply, You were saying
Sure.
something to the effect that there's a difference between the reporting of non-fatal injuries and fatal injuries, and that in Texas somehow something's wrong in that respect.
So
that's what I got.
Louisiana is the most egregious. So if you look at, if you rank states by which states have the best non-fatal injury rates, well, number one, Louisiana or states like that.
That means they report the least amounts of people being injured on the job without dying. Was that what you're saying?
It's an incidence rate, so it's per man hours. So it's full-time employees. It's just essentially if you use the full-time employees, ratio. It's a ratio using the full-time employees and hours work data. Anyway, the point I was making was that so states that have low non-fatal injury rates have high fatal injury rates, higher than predicted. If you were to say, well, how safe is the sector, given its non-fatal injury rate, which is a frequency, and it's measured with surveys, which is obviously not as reliable. Fatal injuries, there's an obituary, there are medical records that are much more robust. There's an autopsy and so right. So there's data that is more reliable and more consistent across states than elsewhere, and so you can get that data openly. In very difficult with very difficult collection methods via the BLS, because it's not a very easy interface to say the least. And then that's actually something that there's a lot of issues with data reporting of injuries in general, that if that were to be improved, we could do a lot better job as researchers understanding what's going on in the workplace. And they've made major strides, but that's a major area of improvement. So one of the main, so we did this aggregated analysis, as I said, and for both fatal and non-fatal, and they both came out the same way. And Bentley and I were talking before this panel, and we were just talking about some of the possible issues with the models, the differences framework, and so I'll leave that to maybe a later part of this panel or afterwards. But the Illinois-New York State case study is much more relevant, I think, for this panel and this discussion, in that what happened in Illinois. So first of all, if you compare New York and Illinois along major structural variables, first, they both have extremely highly developed workers' compensation systems. There's a National Academy of Social Insurance ranking of states, and they buy workers' compensation systems, and New York State and Illinois have almost 100% of workers who collect unemployment insurance. Federal unemployment insurance able to collect workers' compensation. So the second area of similarity is that they both have very large metropolitan areas with high amounts of density. And if you normalize the number of high-rises built since 2000 by population, so I think it's about 100,000 per 100,000 people or 200,000 people, you find that the states had the same number of buildings built per that population. So that's another area. So the density question goes out the window in many ways because of that aspect. You can't explain the differences away to the economic fluctuations or the differences in other structural areas. So what happened in Illinois is that Illinois did suffer a much greater financial crisis than, a much worse slump in their housing market following the global financial crisis than New York State. But what we observed both before and after the financial crisis is that Illinois experienced a rapid and extraordinary decline in its fatal fall. That's the important part, is its fatal fall. So as Melanie said, that's the most important element if you're looking at safety in the sector, right? That's the type of injury that you can't prevent by learning on the job, by the natural way that people learn is by trial and error. That one you can't learn from that way. So that's really unusual. Before the global financial crisis, the decline was actually greater in Illinois, which is unusual in that that period is a period of a bubble in which a lot of unskilled workers are entering the workforce. in construction, and so a lot of places around the country saw a bump in the number of in the fatal incidence rate. So that's sort of strange as well. So New York did not see that, and that's not to say that that's directly the result of law. That's not the point here. The point is simply that the repeal of a similar statute in Illinois did not cause both, if you look at it before, before the, if you could look at it from 1992 to 2011, so before the repeal in 1995 of a similar statute, you do not see the rise in the number of fatalities in the sector. You see a decline in both frequency of reported non-fatal injuries and a decline in fatal fall incidences in Illinois.
And so, Jacob, at bottom, I guess what your study reveals is that, and I don't want to put words in your mouth, but in some substance, that the scaffold law in New York doesn't seem to avoid or have the effect of avoiding as many fatal injuries as the repealed statute in Illinois. Can you make that conclusion?
If those two laws, and there's plenty of reasons to believe that those two laws they're not directly substitutable because of the way case law is organic and extraordinary. That you can't directly compare the case law. But what you're saying, yeah, essentially is.
All right. Well, you carved out a caveat, if I understood you correctly, that these laws are not directly substitutable because they're different in how they're drafted, in their language or how they've been interpreted. Is that what you're suggesting?
They're very, very, very similar at the statutory level, but from a case law perspective, across states, the evolution of the law is different simply because there are courts come to similar conclusions based on experiencing similar events, but there were differences in the rulings that they found. But what's interesting too is that the number of citations to the law. If you look at across the United States, you say there was an article in the New York Law Journal last year, and it said no, other states also have scaffold laws, and it looked at a number of states, and it said that if you look at, I think it's Missouri, and it looked at Puerto Rico even, right, and said there also have scaffold laws. But if you look at the number of citations, you go on Westlaw or normal law database, you look at how many citations to law are there, how much is this law actually being applied in the courts, and what you find is that Labor Law 240, the best way to understand how it's different from what occurs in other states is that it's unusually expansive and has an unusually large number of citations, and so that's really something special. If you go on Westlaw, it breaks the number of total citations that the default setting allows you to print. And so if you look at other states, it's you can add all of the other cases up except for one other state, and you get to almost the same number of citations. I don't know if that's completely clear, but the point is simply the amount of the amount of case law that's been generated by the statute is very, very unusual and very, very expansive. And in recent years, it's gone up. Since 1990, I believe it's gone up fivefold. To give a rough measure.
Okay. Professor Griffiths. So you have a long and distinguished career in construction and in engineering from an educational point of view, and you've written a lot in the area. It seems that a lot of what you've been concerned with over time is the actual implementation at work sites of safety, and how do you best create a safety culture, and how to basically how do you make these places safe as possible for everyone concerned. Having said that, the audience here, I think today is mainly interested in this proposed statute, CPLR 1414, which would amend, interestingly, the civil practice law and rules, and not the labor law to section 240 itself, but to allow a comparative negligence element to come in. And I'll just interject from a lawyer or judge's point of view. This, I verified earlier this morning, this statute goes back to 1885, and the amendment that created absolute or strict liability, however you want to technically put it, occurred in 1897. So this thing is over 100 and something years old. What's your take, Professor, on whether or not this, the status of 240, and should you have comparative negligence introduced?
First of all, I don't know. You know, it kind of reminds me, I heard Jacob here talking, you know, how much I used to know when I was a PhD student and how much I don't now. First of all, I got to apologize to everybody for me being here because I don't have any business being here talking about this statute. Because I think when you reach this statute, in my business, you're a failure. Okay, you've already had an accident. Okay, and I don't think you should have accidents. My introduction, which thank you very much, my dad would have enjoyed it. My mother would have almost believed it. But my first lifetime was 26 years in the Corps of Engineers. Started out as an apprentice iron worker, and then I was a Corps of Engineer officer for 26 years, trying to figure out how to make projects safer, actually on the job. Some I was very successful with, some I'm very unsuccessful with. So I've got to tell you, I come from a whole different point of view. My wife has asked me not to do any more expert witness testimony. We've shown it time and time again, you can have a safe job. The problem is people just don't pay attention. They don't wake up in the morning and think, I'm going to have a safe job. Okay, they go on. First of all, every time you have an accident, we put out another regulation. And we keep getting regulations and regulations. And how do we, in the construction industry, treat those regulations? Well, one, we put posters up in the trailers. We send people for training and education. We hire a safety officer, because we have to have one now to keep all the statistics. And then we have toolbox meetings. And then we declare victory. Okay? And then we go on until we have the next accident. Okay? You'll have accidents on projects because you don't have leadership on projects. You know, if you had the leadership on the project and actually focused on not having accidents. Look at the national record, national average for, recordable incidents. And then look at the Construction Industry Institute member companies down in Texas, mostly in the process and power industry. And there's an order of magnitude difference in the safety record. You look at DuPont, Dow, Exxon, these commercial firms, they don't have accidents. Okay, if they do have an accident, they throw a tantrum. I talked to the last Department of Buildings when we were having so much trouble with those crane accidents, and I said, stop worrying about the details. Stand up and throw a tantrum, and don't allow accidents in this city. And they ought not allow accidents. So I recognize that I'm not talking about on this subject.
No, that's all right, because actually the title of the forum today of the program are New York's Construction Safety and Insurance Laws Serving the Public. And so very much, this particular statute that's very much in the public arena right now, is what I think draws people here. But your greater point is that there's there's entire big corporations that have really good safety records, and perhaps if that's copied across the board in the construction field, maybe we wouldn't be that concerned, let's say, with this particular reform.
Absolutely. Let me just read you something here. This is one of the worst things that I don't think there's anything wrong with the Department of Buildings. The Department of Buildings didn't crash. It was a crane that collapsed. Keep in mind that construction is a dangerous business, and you'll always have fatalities. I was in the New York Times, June the 1st, 2008, and Mike Bloomberg said it, okay? You'll always have fatalities. That's not true. You shouldn't have it at all. So anyway, what do I think about the scaffolding law? I think it ought to be fair. I think you ought to do what's fair. And I think that would probably mean changing the statute a little bit. But that's my legal opinion.
All right. All right. Jeff, you've come down from my alma mater, from Cornell. Probably just escaped all the snow and all that bad weather, but Ithaca is really a beautiful place to be most of the time. I wish I could find a way to do that myself. You have a long background in the construction industry as a worker, an electrician, as a consultant, and as a teacher, an educator. What's your take on what we've been discussing here today, and in general safety, and in particular this statutory amendment that's being proposed?
Well, thanks for having me. I'm actually based here in New York, so I didn't have to contend with the weather, which was great, and I feel like I might be an outlier sitting on this side here. But in the interest of full disclosure, let me just begin with a disclaimer. I'm not a lawyer. I'm not an economist. I'm not a health and safety expert. I'm a union electrician by trade. I'm a labor educator by profession. And I am a trade unionist by conviction. And I'm not a neutral commentator on this question. 30 years ago, my best friend fell from a scaffold and broke his neck. And so I take this very personally, what it is that we're talking about here. And I just want to kind of pick up a little bit on what, is it Bud?
But
What Bud was saying. In terms of addressing this issue contextually, just thinking a little bit about the industry itself, because construction is a fiercely competitive industry where contractors generally secure jobs by offering the lowest bids and make profits by performing the work at the lowest possible cost. And this kind of competition can be very positive, enabling the very best contractors to succeed, so long as that competition takes place on a level playing field. And one of the ways to ensure that there is a level playing field is a strong regulatory infrastructure that prevents unscrupulous contractors from underbidding their more honorable rivals by cutting costs, ignoring job specifications, violating building codes, driving down labor costs, and compromising safety. And unfortunately, to inject some reality into the conversation, the competitive pressures of this industry in fact induce some contractors to cut corners and cheat. That's the reality that we're dealing with. And one example, that's very clear is the widespread problem of payroll fraud in New York State, where in 2013, 20,000 workers were misclassified and $300 million of wages went unreported. So the first point I would make is, absent a strong regulatory environment with rigorous monitoring and enforcement, some contractors are drawn into this destructive kind of competition that becomes a race to the bottom. And that has, negative and potentially calamitous consequences for legitimate construction employers, for construction users like us who are living and working in those buildings that are built under those circumstances, and especially for construction workers whose lives are put at risk. And let me just comment very briefly on what some have mistakenly referred to as the Cornell study that Jacob talked about. This was a study that was done by a Cornell faculty member, assisted by Jacob, a student at Cornell. But it wasn't done in association with Cornell University. It's a Rockefeller Institute study. And in fact, a number of Cornell professors do not regard this as a definitive study, including my colleague Rick Hurd, who has spent his entire career doing research. He's an economist doing research on labor regulations. And he just regards the conclusions of this study to be both inaccurate and derived from some pretty flawed statistical methodology. I just want to sort of set the record straight on what study we're talking about and whether or not it is in fact a definitive study on an exceedingly complex set of issues.
Okay. So, the state of the law on the question of sole proximate cause, right, which is the only way in a case that falls under 240 subdivision 1 that an owner or contractor can defend, in essence, against a claim, is that the defendant has to show that the plaintiff's failure to use a safety device was the sole proximate cause, And they have to show three things: that the device was readily available, that the plaintiff, meaning the worker, knew that he or she was expected to use it, and that plaintiff, for no good reason, chose not to do so. So three things: the device is available readily, plaintiff knew that he or she was expected to use it, and it's not constructive knowledge, it's actual knowledge, right? And that plaintiff, for no good reason, chose not to do so. Jeff, I hear you loud and clear about bad construction actors and the race to the bottom, and that probably exists across industries in this society of ours. But you know, some people in this audience might say, look, you know, for example, the first department in the Torres case last year, Torres versus our townhouse. So a fellow decides to climb down a tree to get onto a 12-foot high sidewalk bridge to get down from an elevation. There had been a ladder at the work site, right? But the first department said, and there was no evidence that the worker knew that the ladder, that there'd been a ladder in the chassis underneath the truck at the work site. No evidence was presented that plaintiff knew where the ladder was or knew that he was expected to use it, and that for no good reason chose not to do so. You know, from an industry point of view, people might say, well, you got to know you can't climb down a tree, you know. And I'm not being facetious. And so this is perhaps, you know, an extreme example. But generally, you know, across the board, I'm opening this up to all our panelists here, right? The notion is that if you do something yourself that's negligent, then you should have responsibility on some level for that act. I understand the statute's over 100 years old, and it came about in a time when people were flying off buildings, you know, back in the late 1800s into the early 20th century. How many people died, you know, building the Empire State Building, for example? So if you or anyone else would want to comment, you know, that's to my thinking, if that decision, you know, kind of makes legal sense because it kind of tracks the Court of Appeals decision in Gallagher, but I don't know if it makes common sense. I'm not taking that position, but if you want to say anything, anybody on the panel, Jeff?
Yeah, I mean, let me speak to it, and I don't want to address the particulars of an exceptional case. I just want to like bring the perspective of a construction worker into the conversation, because the competitive nature of the industry doesn't just impact employers, it impacts workers in the industry. Every time a construction worker arrives on a job, they're working to put themselves out of a job. Every construction job is a temporary job. And so employment insecurity is a fact of life for workers. And under those circumstances where you feel incredibly insecure on the job, it's perfectly understandable why a worker would be reluctant to stand up and speak out when they're faced with an unsafe condition. And I know from personal experience the difficulty that a worker has in confronting or challenging a foreman who's asking the worker to do something that the worker, you know, questions whether or not, in fact, it's safe. And I really appreciate Bud's point about the ways in which you can have kind of zero tolerance with the right kind of leadership on the job. But in many circumstances, workers face a dilemma on a construction job. They're forced to say, do I speak up and refuse to do something that I believe may be unsafe and risk my job, or do I do it and risk my life? And I don't think any worker should be faced with those kinds of choices, and those choices confront workers, you know, every day. And let me just add one piece to this, which is when a worker is reticent to speak up on the job, the industry has really denied the value of the wisdom and the understanding of how construction works that worker brings to the industry. I'm often reminded of the famous quote from the Wobbly leader, Big Bill Haywood, who said, "The boss's brains are under the workers' caps." So I would say that in addition to, and I'm clearly arguing for, in addition to a strong regulatory environment to protect the safety of workers in what is an inherently dangerous industry, I think giving workers collective voice that comes with legally protected union representation, for example, that empowers them to identify job site hazards and bring them to the attention of employers who control the work site and should in fact mitigate those hazards, is an important element in creating what is, as I said, an inherently unsafe or dangerous industry to transform into a much safer industry where there's zero tolerance for accidents.
Thank you very much.
Could I just make one additional quick comment? When I was 40 years old, I finally realized my dad wasn't as dumb as I thought he was as a teenager. And I asked him, I said, how'd you get all those safety? He was a labor superintendent for Florida Power. I asked him, I said, how'd you get all those safety awards and things? Because I was going to Germany to command a 1,000-man battalion, and I wanted to figure out how to have nobody get killed. So I thought I'd ask him how he did it. He had a rule, and I want to tell you how that guy, you could have stopped that guy from climbing a tree. That rule was every morning, or actually any time a supervisor got any workers together, he had to talk about safety. No options. I mean, you picked up your pink slip, you didn't talk about safety, he found out about it, you're fired. No appeals. So if that foreman had said in the morning, like same thing he said yesterday morning, same thing he said the morning before that, don't climb a stupid tree, or don't do something stupid, chances are the guy would have thought, I ought not be doing something stupid today, so.
Okay. Sure, Professor.
Yeah, so poor, I sort of feel sorry for you. I mean, you don't have all the war stories that we all have here to sort of push your case for, but just a couple of points. First, there's a great book that everybody should have, is How to Lie with Statistics. You should all read that, and I think one of the reasons the common law system has been so successful is because judges are able to use very contextual information, so the quality of information you have in each case is very high, and so you have these two contrasting views. There's sort of statistical view and the common law, sort of judge-based law. Given that caveat, you're still an undergraduate. If you come to Columbia to do graduate studies, you'll actually learn that the BLS is not sufficient to, in fact, do empirical work. In fact,
Bureau of Labor Statistics.
Yeah, the Bureau of Labor. In fact, one of the things that's really hard nowadays in economics is we really want to emphasize what is the causal effect of a rule change. So if I were to change this rule, so the question we're asking today, if I were to change it compared to the next rule, will that improve outcomes? That's a really hard question. I don't know the answer. Now, what I'd like to do is I'd like you to change the rule, and I'd like to change it back again. Then we can sort of see if it works. That's the only way for it to work. The stuff that I did on medical malpractice law, what we did, it took me 4 years to collect the data. We hired law students, lots of them, over several years to collect the data on the law changes. Several things I learned from that. First, law students make mistakes. Right? There are a lot of mistakes in the database. Secondly, the publicly available data on the American tort reform law was wrong, so they didn't know what the law was. And we got it figured out eventually. So with the guy with Ronan Abraham in Northwestern, we figured it all out, and I think the law that we have now online is relatively correct, but it was a lot of work. So simply figuring out what the law is and coding up is hard. And what we did there is we looked at how the law in different states changed, and we used the US as an experiment and said, here they changed the law, there they changed the law, and then we used all that data to figure out what was the effect of tort law, and we found there was an effect. So that's sort of, so in this case, I have no idea what this law will do. What I can say, I'll give you my one war story from my dad, which goes back to your statement on workers, is now in economics we have more what we call behavioral economics, and that is we just know that people are not good at doing short run and long run decisions. So when my dad was in Cyprus, he was a military officer, and you have all these young guys there. So what's the first thing he did when he arrived in Cyprus to do as a peacekeeper? He removed all the guns from the individuals, because he knew if you're a young guy with a gun, what do you want to do? You want to shoot it, and then once you've done that, that's a mistake you can't go back from. And so he just removed the guns, and that increased the safety of the environment. Now, if we're working in a scaffolding, well, we can't remove the height, but we can put things there, and you have young guys up there, and they'll just do dumb things. It's just young people, they're there, they're invincible, right? I mean, I remember I worked in the woods, and I would go up trees, and I would fight with bears and stuff like that, and I thought I was invincible, right? But people die doing that, and I have lots of friends of my age who died in crash and accidents. So the thing is, if you have young people, under 30 on a work site, you have to provide leadership, right? You have to provide them kindness. They're impetuous and so forth, and that cannot. And if you sort of put that as an obligation on them to prove that they were impetuous, well, they are impetuous, and so the question is, you have to take that as given that they'll be stupid, and then create an environment to deal with that. Now, in terms of regulation, so the second question, should we use regulation? The construction industry is heavily regulated. We have a lot of building codes. The reason we have building codes is precisely what you're saying. We have a building code because buildings fall down without them. We tried an environment with no building codes. If you go to Turkey, just look at the building. There's an earthquake. There's a building code. It was obviously ignored. All buildings fell down as soon as there was an earthquake. And I used to live in LA, and one of the things I really appreciated in Los Angeles was actually the buildings are really good. The reason they're good is because buildings fall down. So we do, but the thing is, regulation as economists, we don't like that, because the problem is once you got a regulation in place, like a law has been there for 100 years, that's very static. So the tough problem is, how do we create a dynamic environment that makes things better? And basically what we need is more information. So you cannot do it unless you know who's dangerous.
So,
and so,
right, go ahead, I'm sorry.
So let me just finish that. So what I would say is, going on Bud's point, is the insurance companies, not the Lexus, what I want. What you want is, when you bid for the contract, you have to know who the safe and dangerous contractors, and you have to be able to price it. If you cannot price it, then you cannot have safety improvement. It's impossible. So if two contractors, one's safe, one's unsafe, and they both get the same price for the contract, then unsafety is built into the system. So the only way safety can improve is you have to reward people for doing that trade-off, right? It's just no other way. And so I think, and that's what economists call incomplete contracts or incomplete information. So the information problem is at the level of having, and I'll just give you one final example. Did anybody eat at restaurants here? ABCD, you ever see the ABCD system? Right. So do you know that people die from food poisoning in the US? Turns out that's true. You didn't know that, but anyway, it happens. In Los Angeles, brought in the ABCD system. What they found is, what this ABCD system does, all it does is provide information about the health report cards. It doesn't do anything. There's no regulation. All it does is say, this restaurant got this rated on a health report card. That's it. So it did nothing except provide information. You know what happened? Death due to food poisoning in Los Angeles fell, because the market responded. That when people went in and said, well, there's a seat, I don't want to eat there. And just that market pressure resulted in restaurants in increasing their ratings and providing a safer environment. And so there we have an example of providing more information and rewarding restaurants that had safer environments, then resulted in safer outcomes. And so the information, I can't emphasize how important it is, and then this trade-off between, and then when you cannot get the information, then you bring in regulation. So regulations typically brought in.
So here's my question. So, and I hate to interrupt you, but
I'm done.
I really do. No, I mean,
No more
the
stories.
take I'm getting here is that perhaps if in the construction contract process, if there was some mechanism by which potential contractors had to show their record, their safety record, the level of accidents they've had in the past, and that this was a uniform disclosure across the board, that might help ensure greater safety on one level, right? I may be oversimplifying things, but I'm getting a sign for 5 minutes. And I think you and Jeff have serious concerns about the study itself that Jacob has presented to us, with causation. And you said other folks up at Cornell even have these concerns. But here, here's, I'm going to throw this into the arena. So from a purely practitioner's point of view, from a judge, from a mediator's point of view even, the plaintiff achieves summary judgment on a fall from a ladder, from a 2-foot elevation, and claims a back injury, okay? The same kind of injury that, anybody who practices personal injury law might tell you, someone would claim in a whiplash situation. The plaintiff stops working. The plaintiff gets an operation. The plaintiff now is if he's a young person, has a 20, 30-year work expectancy at, let's say, $50,000 a year, if not more, with benefits. You're talking millions of dollars in lost earnings. He has summary judgment because they can't establish, sole proximate causation. Every day that goes by while that case is pending in the courts is the defendant's looking at 9% interest, compounding. At the end of the day, that the only recourse the defendant has is to go to a damages trial. And people in this audience might say, well, that's very difficult because the jury isn't going to know necessarily he fell off a 2-foot elevation. They're only going to know that we're liable as a matter of law. So we're starting from behind the 8 ball. And that can, you know, as you might imagine, cause a lot of people to say, you know what, my best option is to try and settle this thing, because I can't leave this to the whims of a jury, who may not know what I know, and probably can't get into evidence, let's say. So I think I'm getting a lot of positive head nods out there. This is something that resonates with a lot of people in this audience. I mentioned this to you earlier, Professor, you know, this morning, and you had an interesting take for that scenario, which is an all too common one in this field, short of this type of major statutory change. Can you share that?
Yeah,
with me?
I mean, the case I've read, like when I did stuff on construction law, going back to what you were saying about cheating, what I have seen in some cases, and I guess, there's a guy, Sweet, I read some of his work at Berkeley. He's a really good construction lawyer. Is the judges often know a lot of the tricks that contractors use, and one of the problems we're facing when we're dealing with jury trials. So there, among many people have some problems with jury decisions. First, for two reasons. First, they can't really assess damages very accurately, and secondly, they can't necessarily deal with the information. So, some system which brings informed parties, some sort of arbitration system, may be another way to go. The back injury stuff, I always talk about accidental death. I had a student once try to look at back injury. Back injury is a huge problem, and that's well known, because it's very difficult to know whether it's legitimate or not. Are they lying or not lying? It's a hard problem, and I'd sort of like to put the back injury aside. And I'd sort of also point out that using a single case is not a good argument. So we have to do with lots of cases. There will always be mistakes. You'll always be able to find a mistake. And from a gross point of view, a couple of mistakes is really not a big issue. So the question is, on average, whether it helps. And certainly, I think the issue here is not, let's stick to death. So the person's died, so forget about the backs. Then they should be compensated, regardless of cause. That should always occur. They should always be compensated for that. Then the question is how to allocate liability. And certainly, systems which would avoid a legal system that removes information, which is describing, go to damages, doesn't strike one as sort of sensible. Having some system where you have a professional arbitration board or some sort of arbitration clauses which allow people to make who are professional, who understand the industry well, helping to make decisions that would make more sense than having a jury trial. I can't.
I mean,
Well, can I-
Bill, I know we have a 15-minute break, Terry, coming.
Into it.
If I can indulge, I don't know if you would want to go maybe for another 5 minutes here, just to complete the panel, but certainly.
Well,
Yeah.
let
Could I
me
make a point? I just wanted to respond to a couple points here.
Sure. Then I'll let Jeff go, and then we'll close it. Okay.
Okay. So there's a few things. So first of all, I haven't really heard any thought about how to consider the opportunity cost of a statute that's even if you took from our study, and I wasn't part of this estimation, but even if you took a low end estimate of what the law's general economic or like legal costs, what it comes out to, it's going to be in the billions range, right? So but if you think about it in terms of regulation, like if you think about look at the federal OSHA budget per year, it's $700 million a year. So if you think about it, this statute is has a greater economic footprint than the entire OSHA budget, potentially by a factor of 2 or 3. But the thinking there is that it's hard to believe that. So the thing is that OSHA. It's either OSHA doesn't have a large enough budget, or isn't playing a good enough role, or there's a huge problem here in New York State that we have a law that on the common law side, has major costs associated with it that are not the cheapest, most cost-effective way to reduce accidents. And so that hasn't been addressed here. And I think that talking about what minor tweaking of the law would do to switching to a comparative negligence, yeah, that's fun from an academic perspective. But in reality, if you look at this from an economic perspective, you look at this from a strictly what would be the most efficient way to reduce our accidents to zero, as Bud mentioned, it's not to spend $3 billion on something that where we've had a basically stable fatal fall incidence rate for about 15 years. And you could say that that's for whatever reasons, but the point being, if the rate is stable, the incidence rate is stable, that this is a serious problem if you're going to be spending $3 billion a year to try and combat that with tort laws. And that's an overly simplified view of the situation. But that way of thinking has not been present in this discussion. I think that's really a failure on the part of this panel. Like just that's an area that if you think about how many things are given up, how many infrastructure projects are given up for a statute that even if it is playing a role in reducing, even if it were to be demonstrated that it was playing a role in reducing incidence rates, it wouldn't have been demonstrated that the marginal reduction, that this is the best way to go about it, and that we shouldn't switch to other means of doing so, like accident. We could do injury taxes or other ways of like bypassing even regulation, because as Bentley said, that's not often perceived as in an economics perspective as being the best route forward. So you want to look at it from an entirely macro perspective. What's the overall footprint of this law? Not simply, well, if I switch to the comparative, how great of a journal paper will that make?
So I'm going to interrupt.
Three things in conclusion. Number one, we think that those cost estimates are wildly exaggerated, and we just don't think the Rockefeller Institute study is definitive on that question, number one. Number two, what's more preposterous is the conclusion of the study that by eliminating safety regulations, we actually increase construction safety. The evidence isn't there. But thirdly, I think most importantly, just to reinforce the point that Bud was making early on, while it's not easy to increase the level of safety in the construction industry, it's not a mystery about how to do it. And let me just speak to that before we conclude. I had the opportunity after September 11, 2001, to help organize and coordinate the World Trade Center Emergency Project Labor Management Partnership, and the honor of representing the Building and Construction Trades Department on that partnership, addressing issues of safety during the restoration of services at Ground Zero. And on what was clearly the most perilous construction site in North America, that project was completed 8 months ahead of budget, $1 billion, 8 months ahead of schedule, $1 billion under budget. 2,000 construction workers worked on that project, performed over 3 million hours of work, with an injury rate that was half the national average. There were only 35 lost time injuries. There wasn't a single life-threatening injury. During the same period of time, 50 construction workers died on construction sites in New York and New Jersey. It's not a mystery. So what were the factors that contributed to that kind of record, which was, quite phenomenal? And I would suggest there are 5. The first was the use of a highly skilled unionized workforce that benefited from state-of-the-art training. The second was a site safety training and orientation that prepared workers for job site hazards they would confront and did the kinds of things that Bud was talking about. Number 3, a functional union steward system on the job that helped inform workers about the hazards on the jobs and that gave them a strong collective voice on the job. Number 4, employers who worked in partnership with building trades unions to ensure that the job was as safe as it could be every day, every single day, focused on safety in the way that Bud was talking about. And 5th, not the only factor, but an important factor, a strong regulatory infrastructure in place with a lot of oversight and monitoring from OSHA. It's not a mystery on how to do this. A strong regulatory environment is one important intervention. It's not the only one. Your idea about a bidding system where it's not just the lowest bidder, but the lowest responsible bidder. And the responsibility is articulated with a clear set of metrics, including a safety record, that creates a level playing field so that we all benefit from a competitive industry where the best contractors perform the best work for construction users. It's not a mystery, we can do it.
Thank you so much, Jeff. Thank you, Professor Jacob, Bud Griffiths. Thank you all.
Yeah, no, I guess I have to think more. I have to think more about your proposal.
January of 2004. Judge Smith is a graduate of the Stanford University and was an editor-in-chief of the Law Review at Columbia Law School. Judge Smith practiced at Paul Weiss, Rifkin, Wharton, and Garrison from 1968 to 2003. And in 2003, Judge Smith was appointed to the Court of Appeals by Governor Pataki. That's with an I. Brian, on our end over there, Brian J. Shute is a partner in the firm of Sullivan, Papin, Block, McGrath, and Canavo. He is a member of the Office of Court Administration's Advisory Committee on Civil Practice, the Board of Editors of Warren's Negligence in New York Courts, the 6th edition, and the American Academy of Appellate Lawyers. I'll just note that, Brian, you were also on this, the infamous landmark case of Blake, and that you, Blake neighborhood, and you submitted an amicus brief.
Right.
So you were very involved with that. To my right, we have Matthew Ross. He's a partner and senior trial attorney with Wilson, Elser, Moskowitz, Edelman, and Dicker, focusing on the defense of construction accident claims, with extensive experience in state and federal courts. Mr. Ross also served as an advisor in the U.S. Army Judge Advocate General's Corps at Fort Eustis, is that correct? Virginia, where he was chief of the military justice branch as a criminal prosecutor. Brett, there you are. Brett J. Nomberg is a partner and senior personal injury trial attorney and an appellate attorney at the firm Brand, Nomberg, and Rosenblum. He is currently chair of the Tort Litigation Committee for the New York City Bar Association. Stephen Kaplan. There you are. Thank you. Okay, so Stephen Kaplan is the Assistant Regional Administrator, Federal Enforcement Operations for OSHA, Region 2, overseeing the implementation of OSHA's enforcement program in New York, New Jersey, Puerto Rico, and the U.S. Virgin Islands. Mr. Coletti? Yes. Louis J. Coletti has been the President and Chief Executive Officer of the Building Trades Employers Association since 1997. The Trade Association is the nation's largest contractor organization, representing 27 contractor associations and 1,800 union construction managers, general contractors, and subcontractors in New York City. He is responsible for leading the New York City construction industry strategy and efforts in the areas of economic development, government affairs, construction safety, and workforce development and labor relations coordination. John F. Grubin is a partner at Wasserman, Grubin, and Rogers, focusing on construction law, state and local government contract disputes, and commercial business litigation arbitration. Appointed as the first chair of the New York City Procurement Policy Board, which wrote the rules that govern the purchase of city agencies of all goods, services, and construction, and the procedures by which commercial disputes between contractors and the city are resolved. Mr. Grubin was also the founding committee chair of the Construction Law Committee at the New York City Bar Association. Ross J. Holden. Hi, Ross. It's a very large panel. He is the Executive Vice President and General Counsel of the New York City School Construction Authority, a law review editor at Georgetown Law School. Mr. Holden has served as Associate General Counsel at Abasco Services Incorporated and an Associate at MacArthur and English. Christopher Jaskowitz, thank you, is the Chief Administrative Office and General Counsel of Gotham Construction Company and Chief Operating Officer of its parent company, Gotham Organization. Christopher supports Gotham's extensive team by leading contract negotiations with developers, assisting with subcontract negotiations, handling disputes with adjacent property owners, administering the processing of insurance claims, and representing the company in crisis control situations, litigations, arbitrations, and mediations. Paul E. Fernandez is Chief of Staff of the Building Construction Trades Council of New York, which consists of local affiliates of 15 national and international unions representing 100,000 members in New York City. He was a finance coordinator of Bill Clinton's 1992 presidential campaign and worked as a special assistant in the White House liaison's office. Dan Marino? David Marino, sorry. Thank you. Okay, we'll take that. I need one now. Okay, so is Executive Vice President and Managing Director of AON Construction Services Group. What does AON stand for?
Aon. Aon is a word.
Just a word, okay. Consisting of I need a quarterback, of over 130 construction professionals that provide strategic insurance, wrap-up and surety solutions to clients throughout the tri-state region. Mr. Marina graduated magna cum laude from the College of Insurance, where he majored in property and liability insurance. He is a chartered property and casualty property underwriter. All right, did I cover everybody? Thank you. All right, so this is a very, as you can see, a very large panel, and it's a very unique situation because several of these panelists have appeared together on other panels on previous occasions, but never, I don't think, has the industry leaders and the members of the bar sat at one time together, which we do before you today. So thank you very much, everybody, for being a part of this panel. Judge Smith, I'd like to start with you, if I may, to share your view about the cases you've had before you on Labor Law 240 and any salient issues which you see a pattern of it.
Yeah, I think it's probably good to start with me because I'm probably the person up here who knows the least about Labor Law 240. I have, but I know more than I used to, and but what I'm going to try to do is give you in a few minutes my impression of what I've learned really in my 10 years now as a judge. I practiced for 34 years in this city before I was a judge in a world where Labor Law 240 hardly existed. I could not have come up, I think I knew there was such a statute vaguely, but I could not have come up with a section number. But since going on the court, I have certainly have some impressions of which perhaps the strongest is the volume of litigation under Labor Law 240 is absolutely mind-boggling. I remember my first clerk was with me for 2 years and had a rather heavy diet. It got so many labor law, and we don't get 1 million cases a year. We get a couple of hundred, less than that. And maybe he works on a third of them. And by the end of his tenure, when he did his last memorandum on a Labor Law 240 case, he wrote into the memo, "And my hands tremble as I type for the last time the text of this statute." The statute is unusual. I mean, to an ignorant person who knew nothing about it before, it came as a surprise to learn. That you can be liable without fault if you are the owner or the contractor, and that it is in many ways very stringent. I get the impression that although I don't think we've ever admitted that we're changing the law or that we're moving in one direction or another, but there has been a tide. The tide has risen and fallen in Labor Law 240 cases. I guess the high tide in my mind was the Zimmer case in the 1980s, 1985. Still, and I was just looking at it this morning, and it still looks extraordinary to me. That was a case in which a man fell from a 31-foot vertical column, and the defense was supported by expert. The claim, of course, was that safety devices were not present that would have prevented it, and the defense was that in the particular stage of construction that this project was at, it would have been infeasible, even dangerous, to have used any such devices. And from reading the court's opinion, you assume that that is taken as true, and indeed the jury so found. The jury came in with the defendant's verdict. The Court of Appeals reversed and ordered the entry of judgment for the plaintiffs, saying, if there's any safety device that could have prevented the fall, if the absence of the safety device was a proximate cause, that's all there is to it. A kind of a startling result, and led, I think, to the impression that was, I believe, at one time pretty widespread, that if you fell, you recovered, and that was all there was to it. I think there, for a number of reasons, including perhaps in part just a sense that maybe it had gone too far, there was some reaction to that in a number of cases. To me, an important case is the Rokovich case in, when is it, 93, something like that. A decision by, a very good opinion by Judge Hancock, in which he, 91, Judge Hancock, who just passed away within the last few weeks. That was a case, and again, it sort of startles you that the case even got brought, in which a man had fell into a trough 12 inches deep, which does not sound like the sort of thing that a law called the Scaffold Law was supposed to handle, but there was hot oil in the trench, and he hurt himself. And it is the Rokovich case that articulates probably better than any other the doctrine that you have to have an elevation-related risk, that either you have to be at risk because you're up at a height or because some object is up at a height that may fall on you. That the mere fact, the mere literal fact that you fell or that you moved 12 inches down is not enough to permit recovery. That's an important one, and the other there are many important cases, a lot of which I probably couldn't come up with offhand. But another one that seemed important to me was Blake, where despite Brian Schute's best efforts, actually I'm making an assumption of which side you were on in that case.
That was a correct assumption.
That was a case in which a guy fell off a ladder. The jury answered yes to the question, was the ladder being used so constructed and operated as to give proper protection to plaintiff? Indeed, there seemed to have been no evidence in the case there was anything wrong with the ladder. The plaintiff acknowledged that he wasn't sure that he had locked the extension clips in place before going on the ladder. And in that case, despite the well-established rule that the plaintiff's negligence is not a defense, there's neither contributory nor comparative negligence in Labor Law 240 cases, but an opinion by Judge Rosenblatt, the court said the Workers' Own Act was the sole proximate cause of his injury, and this you might interpret as a doctrine of sort of contributory or comparative negligence counts if there's really a lot of it. And that, again, I think has perhaps abated somewhat the sense that I think may have been prevalent at one time in the 1980s, that plaintiffs can't lose these cases, that there's a plaintiff always wins rule in force. Certainly that's no longer true. All these cases I've just described are before my time on the bench. In my time, I think I've seen less drama, and I have seen a slight diminution in the number of cases we get in labor law, but we still get them. We get them all the time. We get them so that when you ask me which was our last one, I say, gee, I can't remember. Was it this one? Oh, no, it was the other one. They go both ways, and the court does not always split on predictable lines. There's a case called Wilinski, in which we essentially rejected a rule that had been followed by the appellate divisions, which, if I understood it, and I'm never sure I do understand it, is that you cannot recover if something falls on you if the base of the object was at the same level you were. In other words, if you're standing next to the Empire State Building and it falls on you, that's too bad. That's not an elevation-related risk. To some of us, that did not make sense, and we rejected it. There are those who, and that was a four-judge majority, in which I was one. I think it was Judge Saparik who wrote the opinion. There were people who asked me afterwards whether an alien had inhabited my body. But the tide rises, the tide falls, as Cardozo said.
Thank you. Judge, could you address the Runner case?
The Runner case.
Yes.
Well, sure, I'll address anything
Thank
you
you.
want. At least I'll address the ones I remember, and I do remember Runner. It was sort of an interesting case. That's the one where the object did not fall on the worker, and the worker did not fall from a height. The worker was pulled by the object down the stairs. He was holding onto a rather poorly constructed pulley, or something that they thought was a pulley that wasn't. And a big roll of, cable, went down the stairs, and he went after it. I believe we were unanimous in that case in saying that on a question from the Second Circuit, that the plaintiff could recover, that there was an elevation-related risk, that there was no reason why this plaintiff should be less able to recover than the guy who was standing at the bottom of the stairs, who would have, if the cable had landed on top of him, there would be no doubt of his right to recover. And it didn't seem to me, or to the other six of us, to matter that the guy was being pulled by the object rather than having it land on him.
So is there a trend now towards gravity-related injuries as being the focus as opposed to elevation-related risks?
Well, I'm not sure I can make a distinction between gravity-related and elevation-related. You can't get elevation without gravity. I mean, it's, but yeah, I think the elevation-related risk is still quite important. I do think there's been some emphasis in some of the cases, and I even saw it in Walensky a little, on whether there is a safety device that could have prevented the accident. A development that may be in some tension with Zimmer, where Zimmer, remember, was the case in which we said it doesn't matter, that it would have been imprudent or dangerous to put the safety device there. The plaintiff recovers anyway. We've never overruled that, but I'm not sure that the present trend of the cases is totally consistent with it.
Thank you very much. Does anybody in the panel have any questions for Judge Smith? Brian, you wrote an interesting article about cases being overruled by implication, and that seems, how is that in this area of law? Is that quite prevalent as opposed to an express overruling?
Well, I think I agree with Judge Smith that it's a matter of pendulum. But, I mean, here in New York, we have an interesting approach. If you think of this as compartmentalizing two kinds of accidents, one, your gravity-related accident leads to a construction injury, and two, everything else, every other kind of accident other than that. Let me read you a couple of statements about the Scaffold Law. The intent of this statute, this is from an appellate court, is to impose a strict liability on persons who erect scaffolds to properly construct and maintain these devices so that those who use them will be protected from the hazard presented by the defective conditions. Fair enough? Second statement, a violation of the duties imposed by the Scaffolding Act, this is by the High Court, imposes absolute liability. Furthermore, where a contract imposes a non-delegable duty to ensure a safe place to work, a general contractor cannot avoid liability by attempting to shift the responsibility to somebody else. The first statement I read was by a Louisiana appellate court about their Scaffold Act. The second statement I read was by the Montana Supreme Court about their Scaffold Act. We have this dichotomy here in New York with respect to just this one class of injuries, elevation-related hazards. We have this statute, Section 240, and I think it's fair to say, notwithstanding what there are other states with Scaffold Acts, including Montana and Louisiana, I think it's fair to say that in New York, we are more apt to impose liability with respect to that kind of accident without fault. But with respect to every other kind of accident that occurs at a construction site, we are actually less apt to impose liability here in New York, those that aren't elevation related. The reason is that many other states follow the restatement of tort second. That imposes vicarious liability in many circumstances in which we don't. Our general rule is, of course, that one who employs an independent contractor is not vicariously liable for the negligence of that independent contractor. That's the general rule everywhere else, too. But the restatement of tort section, Section 414, makes an exception where the owner controls any part of the activity, then it's vicariously liable for everything. The restatement of torts also makes an exception, Section 416, where you have an activity that is specially hazardous. And under 427, where it's one that requires special precautions. Those two things usually apply together. And another one, Section 424, when any regulation or statute requires a safeguard. In all of those circumstances, those states that follow the restatement of tort second would impose vicarious liability in non-elevation related accidents, but here in New York, we wouldn't. We don't recognize those exceptions. So the mystery, in a way, is, as Judge Smith mentioned, we've had changes in the way that our 240 statute has been applied over the years. Rokovich, 1991. Prior to that, only the Third Department said the statute is limited to elevation-related hazards. Then the Court of Appeals said it, and now that's the law. In 1993, the Court of Appeals decided a case called Ross, dealing with the companion statute that doesn't apply just to elevation-related hazards, but 241 sub 6. The statute actually says that there's a requirement to provide reasonable and adequate protection and safety. But the Court of Appeals construed that to mean in Ross that it applies only where there's a violation of a, quote, concrete provision of this one set of regulations, the Industrial Code, Rule 23 of the Industrial Code of the State of New York. And then Blake and later Robinson cases that I think fair to say expanded the circumstances in which the plaintiff would be, the worker would be barred from recovery as being the sole proximate cause. So the mystery is this. It was mentioned on the last panel that we have all these injury statistics, and we do from the Bureau of Labor Statistics. What we don't have that much is insurance information as to how that's responsive to the injury statistics. If it were, we should have seen, after 1991 and Rokovich was decided, we should have seen a drop in insurance rates, because now 240 is limited to elevation-related accidents, which wasn't the case in 3 of the 4 departments before that. We should have seen a drop in insurance rates in 1993 when Ross was decided, and now 241 sub 6 is limited to those instances in which there's a violation of a concrete regulation. We should have seen a drop in insurance rates in the last decade with decisions in Blake and Cahill and Robinson, yet we didn't.
So I'd like to ask Mr. Marino to respond, if you could.
Sure. I think a couple of points. There certainly is an insurance crisis in the construction insurance space in New York. I don't think there's a dispute about that. There is not a crisis in the insurance markets in Montana and Louisiana, despite what might be something else happening. So we say some other states may have similar laws, but the effects of those laws are playing out differently here than other places. So we are in a crisis. The room is full. There are lots of panels in New York about this subject. It's become a very hot topic, which is why we're here. I think insurance rates are moving up and down with the results of those particular cases. When contractors experience or owners experience, if they're buying wrap-ups, and there'll be a wrap-up panel later to talk more about that, or they are buying insurance over the course of time, rates do move, but we're looking at aggregate numbers over 4, 5, 6 years in those experiences. So it takes time for those loss results to work themselves through the pricing mechanism of insurance. But we have a steep curve on the cost of construction insurance, which is unique in my experience, in my career, in that we're not dealing with a hardening of an insurance market broadly in New York. Other industries are not facing a liability crisis. This is not on the front page of the Times where other industries are saying, hey, we too can't get insurance. This is a construction problem, and it's related exclusively to labor law. The construction insurance market beyond New York is also not facing a liability crisis. So this is not about insurance companies underpricing products broadly in their book of business based on the economy or safety or lack thereof in other states where there aren't scaffold laws. This is a New York issue.
Okay, so you know what, you raise an interesting point, and I'd like to address this to you and Brian as well, regarding, everybody, the insurance situation with respect to, arising from Labor Law 240. I'm going to quote you a case, New York Court of Appeals case from 1978. That's Allen v. Gloutier Construction Corp., sorry. And the court, it reads as follows. The hiring of responsible subcontractors will be encouraged, for any solace based upon a right of indemnification or contribution will be short-lived if it proves that the subcontractor is financially irresponsible. And here's a key sentence. Further, as liability in the normal course will be cast ultimately upon the party actually responsible for the accidents, insurance premiums will be adversely affected, thereby furnishing an additional incentive to both insurer and insured to maintain safety standards necessary to avoid increased exposure to liability. So apparently the court did consider this insurance issue, it is not new, and considered it as a direct, as a means of encouraging the safety issue. So when you say it is unique to New York, it is not a surprise because of the absolute standard, it would seem, and that would be a byproduct, which the court did consider explicitly in this case in 1978. So I just thought that was an interesting fact to put out. Sure. Thank you.
So, I always find it interesting when people use the word crisis. It means they want to get your attention. They want to get your focus. And it's used all over when people want to spread fear about something. But, you know, there's a crisis. You know, you have to pay attention to this. It's important. It's affecting all of us. As far as I'm aware, the construction business is still making money and millions in profits building in New York State and throughout the states. The insurance industry is still making millions of dollars. I'm not aware of any crisis, and if you go around New York City today, you'll still see that buildings are still being built. Putin said that there's a crisis in Ukraine and had to go in and send in the troops, despite everybody saying everything's fine. So when you hear the word crisis being used, you should always be suspicious because they have the ability to show their data to everybody else. And we've been asking for it for years, the plaintiffs' bar and everybody else, and they don't give it. So if there truly was a crisis, turn over the books, show us you're not making a profit, and we will start to listen. And what people said on the other academic panel is absolutely true. You don't base policy and law based upon the insurance company's decision on whether or not they're making enough profit. Insurance is a business. They are there to make profit. And that is not a reason, their loss of profit, they're not making enough money, to change policy decisions on, for example, protecting workers, on protecting anybody. We're not going to change the motor vehicle laws and let people go through red lights because insurance premiums are too high or too low. That's not the sole basis of how we decide what laws are good for all of us and what are bad. So just, it always irks me when I hear the word crisis. It sends a red flag that I don't necessarily believe what you're saying. That's all I had to add.
Let me respond to that. I don't think, in fact, I know that this is not about insurance company profitability. I work for a developer, owner, builder in town. This is not about insurance company profitability. This is about a law that is obsolete. It was drafted and enacted in 1885. Since 1885, there have been numerous laws and regulatory structures that have come into effect that really render this law obsolete. I mean, the law was designed to make owners and builders make sure that the scaffolds were safe. About fault or liability. Under the workers' comp laws, all medical is paid, all testing is paid, diagnosis, rehab costs, that's all paid. And in New York, that worker can also sue, and he can sue the contractor and the owner. Which, by the way, in a lot of states, that worker can't sue the contractor and the owner. So we're not asking to be like other states. If we did something wrong, sue us and win. Seriously, that's how it should be. The problem with this scaffold law is that it's strict liability versus comparative negligence. This is a strict liability framework. And it wasn't strict liability when it was enacted. It became strict liability. The latest amendment was in 1969. That's when it became strict liability. There are no other states that have this. There's no other state in the United States of America that has a strict liability framework like we do. They have laws that reference scaffolding. They were enacted in the early 1900s, but because of workers' comp and everything else, no one else has what we have. So then it comes back down to what this is really hurting. It's not hurting insurance company profitability. It's hurting small businesses. It's hurting all businesses. It's hurting the quality of products that are built.
May
Can
I
I-
respond?
Oh, Mr. Ross
Hang on.
has not spoken yet.
That's okay, I just wanted to follow up. I am going to, my little disclaimer is that anything I say here today cannot be used against me by the Honorable Judge Smith of the Court of Appeals. So, but I do want to comment. I think it's kind of incredible because, statutes are enacted for public policy reasons. They could be for safety reasons, could be for a number of reasons. Statutes are also supposed to have fundamental fairness. And I'm a realist. I've been practicing in this area for over 20 years now here in New York under the labor law. And I'm always mind-boggled. It took me a long time to get used to the fact and say, how can the general contractor, how can the owner, or possibly a construction manager be responsible for this accident? And you're telling me that the individual worker who is supposed to be trained, and I'll take it a step further, a union construction worker in a particular union trade who is held out to be well-trained, OSHA trained, and they have no responsibility? The issue is responsibility, and it was just commented on. This law, as it is still referred to today, is known as the scaffolding law. It was enacted for not ordinary risks, extraordinary risks and perils associated with the type of ultra-hazardous activity that they were looking at with respect to scaffolds and working at these extraordinary heights, or having materials that were hoisted or secured from up above that come down and crash onto somebody when that worker would have had no way of protecting themselves. Unfortunately, and I know there are ebbs and flows, but the tide, in my opinion, has certainly turned grossly the other way, because it's no longer looked at by the courts as one of these extraordinary perils. In other words, what is the individual doing that required that individual be protected? It has shifted from, now we're going to talk about some elevation of gravity related, and Judge Smith commented on one of the most recent cases that came down, which is this Walensky case, where the worker who was injured was not doing anything extraordinary, was not working at a height, was not working underneath materials that were being hoisted or secured. He was merely working at ground level, and there were steel beams that were stacked and they were standing up at the same level. It just so happens that the worker was about 6 feet in height and the steel beams were 10 feet in height. So when those beams fell over and struck the worker on the neck, the court held that that 4-foot differential and the weight of the beam was enough to say that there's at least a question of fact. In other words, they didn't say that 240 was violated, but what they did was they reversed the lower court. I think they had reversed the lower court's the summary judgment. The lowest court summary judgment had been granted in favor of the defendants, saying that this was not a 240 case, and then the higher courts reversed that and said there's a question of fact, and was there a protected device? Now, it could be that there may be some other violation there, maybe something else could have been done, but this statute, remember, it imposes absolute non-delegable duty. In other words, what is an owner or a general contractor to do? And I'm going to cite one other example of realistic case studies. You have a construction worker, a union-trained construction worker, okay, who's working in a classroom, and they're using a Baker scaffold, which is a Baker scaffold that has wheels. This scaffold is 36 inches high. That's it, 3 feet, maybe not even as high as this table. The scaffold had wheels. The wheels lock. When you go on the scaffold, you get on the scaffold, you do your work over here, let's say at point A. When you're done at point A and you have to move over to point B, you get off the scaffold, you unlock the wheels, just move it right over. Lock the scaffold, go up. Now, the scaffold's 36 inches in height. There's no guardrail around that scaffold, which is not which is in compliance with New York State Industrial Code, Rule 23, because Rule 23 of the New York State Industrial Code does not require a guardrail on scaffolds that are less than 6 feet in height. Okay, that's the law of the Industrial Code of the state of New York. This is a scaffold that's only 3 feet off the ground. There are construction workers, though, that don't like to get off the scaffold, unlock it, move it. All right? I have come to find that many construction workers, like I always say, like my kids, like teenagers and those in their 20s, they think they're impenetrable. Nothing's ever going to happen to them. So they rock the scaffold to rock it from point A to point B. Nothing wrong with the locking mechanism. After they rock that scaffold, well, lo and behold, they rocked the scaffold and the construction worker fell off the scaffold and broke his arm. 240? Absolutely, court came down. We don't care about the state of New York Industrial Code that doesn't require guardrails that are under 6 feet in height, so there's an inconsistency right there. If the guardrail was there, maybe it would have prevented that worker from falling off the scaffold, and they might be right. Maybe that would have done that. But certainly, if that individual was made to have to take responsibility for their actions, there would be a significant difference. And yes, it would have an actual direct impact on costs associated across the board. Across the board. Cost to the contractors, cost of insurers, cost of reasonably resolving those cases when an individual knows, you know what, I could be found 50 or 60% at fault for that. It would reduce summary judgment practice. Everybody forgets that when summary judgment is granted in the state of New York, an incredible 9% interest starts ticking away from the date that that summary judgment was granted. That has a major impact on labor law 240 cases. Because we all know here that you don't necessarily get to trial within 2 weeks of a summary judgment being granted. It could be a year. And there's nothing you can do about it. So, and what I'm describing to you is an actual case. Now, what's funny is, had that individual worker, the same thing, had that individual worker had fallen and just fell onto the scaffold, there'd be no 240 because the guardrail wouldn't have had an issue. The worker would have rocked the scaffold and that would have been the cause. But because it was unfortunate that he actually fell off the scaffold and there was no guardrail and he was probably the most responsible for his accident, it didn't matter because we have two defenses on a 240 case. Either it's not applicable at all, or the individual worker is 100% at fault. I mean, it's an all or nothing proposition, and that's just not realistic, at least from the cases that I have seen. So it's really a question of fundamental fairness. Again, you want to place strict liability on an owner or a general contractor and say, you know what, you don't have to know that something is going on. That's fine. But the time has come where you have to be realistic, and you got to start putting responsibility on the individual workers so that they can take responsibility.
Mr. Coletti, 1 second, Brian.
Let me
He hasn't
take
spoken yet.
a little bit of a different approach here. We're sitting here in the City Bar Association. I always thought that it was a fundamental principle of our jurisprudence system that everybody deserved their day in court to present their evidence on their particular case. Can anybody here think about any other criminal civil action where a party to a legal action does not have the right to present any evidence in a court of law? I can't. And that's fundamentally what's wrong with the strict liability standard. We are not seeking to stop lawsuits. In fact, in my conversations with anybody and everybody, we believe any injured worker should have the right to file a lawsuit. All we're looking for is an ability to present the facts of a particular case to a third party in those cases where there might be some contributory negligence. This game is rigged. You know, I'm fascinated when I continually hear the conversation about how everybody else is making all this money. Contractors, owner, we're loaded. The insurance companies, let's open their books. Well, let's open everybody's books. Let's open the trial attorney's books. Okay? That's not the issue. The issue is fundamental fairness based on the facts of a particular case, a process. There is no, I represent union contractors. We invest millions and millions of dollars every year training our workers. We are subsidizing the non-union contractor who does not do anything. We had a tragedy last night in New York City. 2 buildings blew up. I'll give you a 10-to-1 odds that the contractor that installed those pipes is non-union. Didn't do any training, didn't do anything. Yet there's no incentive for my members. Take the experience modification rate and how they determine workman's compensation. The contractors I represent are down 1.0, 1.2. You know what that means? Well, I mean, in that world, that's an excellent safety record. You know what that means when you're going to seek general liability insurance? Absolutely nothing. Because the way your premium is calculated is you take all of the 240 claims, which we just heard are just astronomically growing by leaps and bounds, and apply them across the whole industry because there's no standard that separates a good contractor from a bad contractor. And that's all we're seeking in a court of law. Give us an opportunity to present the kind of company we are, and in the particular case, what happened in this case, and let a jury make a determination as to who's at fault. We believe it is the responsibility of every contractor and owner to provide a safe work site. But we're paying the price.
Oh, okay, sorry. Mr. Gruben, he hasn't spoken yet.
I'd just like to make a quick point about something Mr. Shute argued, because it leads to compromise for the reform proposals of the Scaffold Law that are now up in Albany. Mr. Shute argues that while New York, through the Scaffold Law, is tougher on owners and contractors than just about any other jurisdiction where height-related injuries are concerned, it is more tolerant than other states of owner-contractor liability respecting any other site hazard, any other kind of accident. So the present situation then in New York is extremely unfair to victims of any other kind of injury but one involved with height. Because no matter how imagine I'm a worker who had a terrible accident, but it wasn't from anything falling on me or me falling from anything. You know, I have no matter how grievous my injuries, I have a harder time of imposing liability and gaining compensation than not only elevation plaintiffs in New York, but site accident victims everywhere else throughout the Union. So the solution would be, which would make everybody happy, is you have legislation that ends absolute liability of the Scaffold Law, you know, and permits contributory negligence, but at the same time requires that in New York vicarious liability be recognized in all cases. So that would make everyone happy. If those who oppose a Scaffold Law, they believe that this is the cause of all these expenses and of the problems getting insurance, that would be gone. At the same time, I mean, assuming that that belief is true, at the same time, you'd have every other kind of victim of a site accident, besides a height-related one, you know, having the same, you know, being subjected to the same kind of proof than accident victims everywhere else throughout the nation.
Okay, so you know, you mentioned legislation, and I want to bring out an interesting point, if you don't mind. As lawyers, we could think about it. I was speaking with Brian before that the workers' compensation statute, which is a no-fault statute as well, Specifically, the legislature explicitly stated that contributory negligence is not an excuse. And yet, there's no mention of that same type of application in Labor Law 240. In other words, the legislature knew how to impose that bar if it's so desired. So I would like some comments about that. The workers' compensation statute specifically addresses contributory negligence.
Very quickly, and I say this respectfully to the members of the judiciary here, you can't operate a company in a construction real estate industry on trends. And you're right, the statute is very vague. You need some framework.
No, I'm saying it's not vague. The legislature knew how to impose that standard if it wanted to. That's what
On workman's comp.
Workers' comp, the legislature specifically
But we've just heard
inserted that contributory negligence is not a
But we've
bar.
heard this morning any number of cases that have both weighed in on both sides. And that's problematic when you're trying to run a business.
I understand.
So I think there needs to be more definition, a fairer system, and then we can move forward, and I believe you will be able to get insurance companies to come back and to compete in this industry. I mean, the marketplace does very, very interesting things. If insurance companies were making all this money, why are they all leaving? They're gone. If you're a contractor trying to get general liability insurance, I mean, I don't want to usurp my friend Ross. Ask Ross about what happened to the School Construction Authority when their owner-controlled insurance program ended on December 13th. They do not want to compete and provide insurance, and they will tell you because of the Scaffold Law 240 in this state.
Okay, wait a second. So you have not spoken yet? You've
Yeah,
been
thank
waiting?
you.
Got down to-
I appreciate all the arguments back and forth over the jurisprudence of this issue, but the fact of the matter is neither Lou nor I, maybe Ross, but I grant that he's a member of the bar, would be here if this was not an issue about economics. So we can have a debate about what the law is, but the reality is we're here because there's an insurance problem. And yet, the insurance industry fights tooth and nail to release any disaggregated data that would allow us to drill down and understand in very specific ways why it is that we have the problems we do in the general liability insurance market. Now, they're willing to provide certain data to hand-picked consultants that they hire to put out reports, but they're not willing to provide, again, they provide aggregated data. Let me give you a quick example of aggregated data. Last year, the average win total between the Boston Red Sox and the New York Yankees was 91 games. Okay, what does that tell me? It doesn't tell me anything unless I disaggregate the data to know which team won how many games. And Lou's absolutely right, and it's interesting that he raises the point about the difference in how premiums are priced in workers' comp versus general liability insurance. Because in workers' comp, your actual record bears on the price that you pay for the insurance product. Whereas in the general liability insurance market, covers Scaffold Law as well as other incidents, we don't have that actual bearing of performance on how your insurance product is priced. I would point out, though, that nothing in the legislation that's being supported by opponents of the Scaffold Law actually addresses that issue. And even if you had a contributory negligence standard, it still wouldn't address that issue. You would still have your insurance product priced based on not only how you perform in the market, but how everyone that you compete against, the worst of the worst, would affect how your product is priced. What we need to do, and there's legislation that's been introduced, which you may be aware of, the Construction Insurance Transparency Act, which would force the insurance industry to do what it doesn't want to do, to which we say, too bad. You want to operate as a business in this state, you're regulated, you have to produce data to justify how it is you're acting as a major industry in the state. That legislation would require them to provide information in a transparent way to the Superintendent of Financial Services, formerly the Banking and Insurance Commissioners, and allow us to transparently analyze data not on an aggregated basis only, but in a disaggregated way where we could specifically drill down and understand why it is that certain actors in the industry may be driving up costs for other actors in the industry that are actually doing all the things they should do.
Why do we need this law in New York?
Excuse me.
I was going to say, look, I don't know about the finances of the insurance companies, and I only can really speak from the SCA standpoint. But the SCA does an awful lot of work in the city on the public side, and we're not worried about profit because we don't make anything. We have an allocation from the city of New York and the state, and whatever money we get goes to building our schools or paying our other expenses, including insurance. But this last December, our 3-year wrap-up insurance program was coming to an end. Our current carrier was not interested in writing the business, so we had to go back into the marketplace as we usually do, but I couldn't get anybody, we couldn't get anybody to take interest in our program. So I didn't have people breaking down the door to write the SCA's business. Finally, we did get 2 quotes towards the end of December when our program was just about running out. We pay premium. However, we really don't have insurance. We have a fronting policy. Our premium equals our losses. So the insurance company will say, we think the losses after this 1-year program is over will be whatever it is. And they put a little safety factor on it, and we pay that money up front. If the losses exceed that amount, we will pay more. We will pay whatever the losses ultimately are. So this is not a situation, at least at the SCA, and we are about a quarter of the city's capital budget, of having an insurance company dictate premium terms to us that are unreasonable because they're looking to make profit. They're not making anything other than a small administrative fee for fronting a program that we're paying for. Just to give you an example of how, and this is, I think, kind of the rawest form of information, because we don't have a profit motive, and we aren't paying premiums that give us real insurance. But in the last 3 years, starting January 1st, 2011, for the program that expired December 31st, 2013, we paid for an entire program, $11.5 billion capital plan, $286 million. For this 1 year, and we only were able to get a 1-year program starting January 1st, 2014, going until December 31st, we are paying $234 million for 1 year. During the last 3 years, the number of claims at the SCA have actually declined every single year. But yet, because we have to play in this marketplace like everyone else, we have incurred an incredible expense. For us, that means that all of the extra cost for our insurance program is keeping us from building more schools. If we were in New York, New Jersey, or Connecticut, and we know the rates there, what we would be paying is about 1/3, 1/4 to 1/3 of what we're paying here. At $234 million, if we were paying in New Jersey or Connecticut, we would be at $75 million. That's about $150 million of extra premium that we're not able to put into our schools. That, just to put it in raw terms, is 3 schools a year that we're unable to build because we have to have insurance for all of the projects we do in the city of New York.
I think that both Paul and Ross hit the nail on the head about this economics. It really is about the economics. What you just said, the difference between New York and New Jersey schools, what was the 100 and what?
Well, if our program is $234 million, and New Jersey, that same construction program, to insure that over there would be approximately $75 million, based upon comparing the rates per trade in New York, Connecticut, and New Jersey. That's about an extra $150 million a year that we're paying in premiums.
So, and this is a complex issue and I commend everyone for coming and sitting and looking at this panel and listening, because it's very complex. To understand the economics, you have to understand what's happening in the courts. To understand what's happening in the courts, you have to understand the difference between this strict liability versus comparative negligence. And there might be 5 people here that don't know the difference. So I'm going to read. I went to a New York law firm's website this morning on the way here to describe comparative negligence. Since 1975, New York has been a comparative negligence state. This means that even if you're found even if you are found at fault to some degree, you may still recover damages from the other responsible person or company. Whatever percentage of fault is attributed to you is subtracted from the damage award. So if the defendant is found to be 75% at fault by a court, you were 25% responsible, and you could recover 75% of your claimed damages. Okay. So I think everyone on this panel would agree that what's happened in the past 10 or 15 years are these 240 cases have skyrocketed. Everyone would agree. A lot more cases. I think everyone else also would agree that the actual claimed amounts are going up. Some will say $2 million average, some will say $3 million, some will say $4 million average demand. I think everyone will also tell you that they're settling at between $1 and $3 million average. So it's simple. Insurance companies don't have to open their books more than they already have. It's very simple. They raise their rates. It's about risk. So they've doubled their rates because of the incredible risk in this state. New Jersey doesn't have it. Connecticut doesn't have it. That's why Liberty Mutual left New York. Old Republic, Hartford, CNA, Zurich, Farmers, Travelers left New York, left this market. That's what the problem is. It's what's happening in the courts. And that's why we want to amend the law, change the law to be comparative negligence. So we can say, well, wait a second, this worker contributed to his injury because he did X, Y, and Z. We just want that right. That's all it is.
Thank you. Mr. Hsu?
There are lots of things that we can reasonably disagree on. Some of the things, though, that have been said legally are simply just wrong. The insurance costs that you're talking about, of course, not limited to 240. They're your total insurance costs. It was said that this law was changed to strict liability in 1969. Wrong. It became strict liability in 1897. We had an experiment. In 1962, the legislature actually amended the companion statute, 241 subdivision 6, so as to negate what was then the vicarious liability. Do you know what happened? Accidents increased because rather than it provided an incentive for contractors to disassociate themselves from the safety of the accidents, it resulted in an increase of accidents. And so in 1969, the legislature stepped in again and returned the statutes to the way they were prior to 1962 when it was strict liability. It was said earlier that you can't go into court, that is, the contractor can't make its case. It's not so. Under the Court of Appeals decision in Gallagher, it's very clear what the defendant has to do to provide a defense, and it will have a defense if it shows that. One, that the safety device was readily available. Two, that the worker knew that she or he was supposed to use it. Three, the worker did so for no good reason. And actually, that Gallagher standard came from Judge Smith's decision in Cahill some years earlier. That's what you have to show, and if you show it, you have a defense. Now, what does this comparative negligence really mean in the real world if it's enacted in this context? Let me tell you what would happen in actual case law. Because the assumption is, like Matthew's assumption before, you started by saying that workers are impenetrable and they feel that they won't get injured. And then a couple of sentences later, you said, but if there was liability imposed, comparative negligence, then they'll think they're not indestructible because they're actually going to think while they're on the scaffold about they'll be injured and there'll be comparative negligence. But here's how this is really going to focus. Here's how it really work. Olea versus Overlook Towers. A First Department case last year. And you're right, so many of these cases are non-union workers, and it's the worst of the worst, as someone said earlier. Many of these cases they're not your responsible contractors. Here what they did in Olea is they're doing the facade on the face of a building, a 70-unit apartment, and they're working from the terraces of the building in order to do so. And they're accessing the terraces from a motorized scaffold. How do they get from the terrace, which is surrounded by a railing, to the motorized scaffold? They're told to jump. This is what they were told to do. And so the worker jumped. It didn't work out very well. If we had comparative negligence, that wouldn't be absolute liability. This worker who was an undocumented alien, and believe me, he doesn't have the choice to dictate his safe working conditions. He'd be tagged for 30%, 50%, 70%, and the liability of the entity which told him to jump would be reduced. Fernandez versus BBD Developers, last year, First Department.
Not me.
No, not you. Yeah, they gave him a safety device. They gave him a rope, a 30-foot rope for a 14-foot drop. Now, that's not going to work very well, is it? 30-foot rope, 14-foot drop. If you had comparative negligence, it's his fault too, because he should have known what they gave him wasn't sufficient to keep him from falling. Diaz versus City of New York, last year, First Department. They leave an open trench right in the middle of the construction site. So what happens? The plaintiff is directing a truck, walking backwards directing a truck, falls into the trench. That would be comparative negligence. 50% off, 70% off, 90% off, it would depend upon the jury. Instead of saying, close the trench. Now, the reason that we have this differentiation in New York between this one kind of accident, elevation-related hazards, and everything else, is the legislative assumption here, as in other states, was that you have a one kind of accident that, number one, when it occurs, tends to produce very serious injuries. Not every case, but many cases.
And
compared to a trip and fall and other kinds of accidents that could occur on a work site. I mean, not to say it's not as serious that you lose a finger or something in a machine, but it's not the same thing as falling 10 stories. And the second thing that differentiates the single class of accident is they're preventable. They're preventable in ways that are known. You follow the OSHA regulations. You built the scaffolds properly. You don't tell people to jump from the over the railing on the terrace to the scaffold. That's not how you do it. And yes, you that's the assumption. That's why we treat those accidents differently. Now, I agree with Mr. Coletti that it would make a whole lot more sense if insurance were priced to reward good actors and punish bad actors. And that when you have all of these lowest common denominated unions, and in most of these cases, that's who it is, and their injury totals being added into the general insurance rates, and everyone paying those rates, that obviously diminishes any reward that you're going to have from a safety perspective. That's not the way to do it, and I agree with you there. But I don't think that saying comparative negligence I don't think that's the answer, because I don't think in many of these cases the workers actually have the choice to dictate the safe conditions of the site. That's not the assumption. Nor do I think that it's at all realistic to say reducing liability will reduce accidents. I mean, think about it for a second. Drunk driving. Would you ever say, let's reduce the liability for drunk driving in order to reduce the incidence of drunk driving?
May I say something?
Yes.
I represent, for 20 years I've been representing construction workers, and I've heard some crazy stories, and including what, Brian, I had a case where there was a gentleman, he's on a scaffold, and he had to go to the bathroom. I mean, you just think of these everyday things, you have to use the bathroom. So he lowered the scaffold. Supervisor says, no, we don't have time for that, right? Climb down. And he had to climb down because he said, no. You don't understand, most people don't understand that, if you go to Penn Station now, you'll see a bus, really early in the morning, they're waiting, they're picking up all these immigrants that don't have proper cards, and they bus them to somewhere else, and they bring them to some construction site, save on labor costs, and you think that, Joe Schmo, who can't even speak the language probably, has any say when he's not given proper safety devices? If he's told, go up on that roof, and I want you to go fix this and do it this way, you think he's going to be able to say, but where's my harness or sling? They will say, next. and they'll take another person. That's the reality of it, and that's what they don't tell you about, but it's going on. And the people, as you heard from all the academics, who are the people in control? Not the workers. They have no control over who provides the safety devices. When you talk about strict liability, there's a standard. It's not you fall down, you win. It does not happen. It doesn't happen with me. I have to look over the facts. You have to not provide proper safety devices to provide adequate protection. That's a standard. They call it strict liability, but there's a standard to get that. It's not he walks in the door, you win the case, you go to trial 9%. You have to have shown that these people at this site, the owners and the contractors, failed to provide proper protection. Where's the sling? Where's the harness? Where's this device? And you didn't provide it. That's why they're losing, because they didn't provide that protection. And there are plenty of cases when they win, when they did provide proper protection, and there's no case. What they bring out are the ones where, they'll hold these crazy, egregious exceptions. Always. There are always exceptions to the rule. But in the large majority of cases, there are workers who are not being provided proper protection. Go on the top of a building and look down. Before that building was built, it was just steel girders. And these people, they do this every day. It is a very dangerous job. As all the academics said, it is different from everything else. The construction industry is dangerous, and if you make a mistake, you die. Absolute liability or strict liability, it's not just by the way in this industry. Everybody's heard of strict products liability, all the lawyers, right? Absolute liability. What about vicious dogs? Strict liability if you get bit by a vicious dog. It's a policy decision. It's meant for a specific reason to protect. When you hear about the arguments, it's an old law. 1800s is an old law. Murder is an old law. That goes back about 3,000 years well before, but it's still on the books. Maybe we should get rid of it because people are still committing murder. You don't do that. The law has a social purpose and it has a deterrent effect. Just because people are people and they violate the law, happens every day. People steal, people do securities fraud. It happens all the time. That's not a reason to change a law. And they talk about the fairness. The fairness, okay, is in the fact that this is a dangerous job, and as the academic said, these are the people in the control. It's the owners and it's the contractors.
I came here today to try to find out if there was a solution. And if there was one solution, it's clear to me. The non-union companies are the ones that are driving these costs. To those immigrant workers that you talked about, I agree 100% with you. But you know what? They're not the ones filing the 240 claims. I've had my attorneys look at all of the list of the names, of the circumstances for settlements, because when you talk about information on that you can't get from insurers, you sure can't get it on 240 claims and judgments either. So those, you have a legitimate point in that. Those are not the people filing lawsuits because they can't afford to.
I just want to speak. 95% of my cases involve union construction workers, not non-union workers, and not undocumented aliens. While I have some of those, I do not represent defendants in those cases. It's such a small percentage. And so the notion that an individual doesn't take responsibility is ludicrous. The unions have, the trade unions, very strong and very powerful. Every single trade has union shop stewards at every single job site whose primary focus is to ensure the safety of their workers. So the notion that an individual worker can't take responsibility, a union worker who can't say no because the excuse is if I say no I get fired, is ridiculous. So instead I'd rather jump off the building and kill myself instead of saying no, go to my union shop steward or go to the union and take care of it.
Well,
Mr. Kaplan, excuse me, Mr. Kaplan has,
Can we
Mr.
just
Kaplan.
calm down and not have silly debate, and let's get back to actually discussing the topic? Because I'm not interested in hearing
So, Mr.
about
Kaplan-
cases that have nothing to do with the scaffold law, or a guy jumping off a building to prove a point and kill himself, which, let's get back to a serious
All right,
discussion.
so
'cause
let's
this is
hear
not
from OSHA.
serious right now.
Let's hear from
Paul, you know
OSHA.
the case he brought up.
I know
But
it.
those companies have absolutely nothing to do
I
about
just
the
said I have no
scaffold
interest in
law.
hearing about it.
Okay, thank you. Let's hear from OSHA and Mr. Kaplan. That'd be great.
Okay, so maybe the regulator can calm things down a little bit.
It's no fun.
So, I'm going to take a deep breath. So, I believe part of the panel discussion is meant to be a discussion about how to reduce risk on construction sites and how this law actually contributes or doesn't contribute to reducing risk on the construction sites, okay? But before, and I know we don't have too much time left, I just wanted to run down a couple quick points that I was listening to and hearing kind of a comparison and contrast between OSHA law and how we administer our standards and how we litigate our OSHA cases versus how these 241 cases are litigated or decided. One, where there's an OSHA standard, a numbered standard, like in the case of scaffolding 451, there is no infeasibility defense. There are recognized means of correcting these hazards or abating hazards or complying with the standards. So this notion of infeasibility is out the window. For our general duty clause violations, what we call 5A1, which is the general employers have a requirement to provide a safe and healthy workplace for their employees. If there's a recognized industry standard and a recognized means to abate in the industry, whatever that industry is, including steel erection or fascia or stucco work where scaffolding is used, then that infeasibility defense is largely out the window. Talk about root cause versus proximate cause that Judge Smith raised. OSHA will cite, based on both proximate cause, the employee did not wear their fall protection or the scaffold wasn't provided with guardrails. We will also cite, based on primary, secondary, possibly even tertiary root cause. Could be the equipment was never brought to the site, could be employees were not trained on the equipment, could be that the equipment was used, but wasn't maintained correctly or inspected correctly. So that's in our wheelhouse as well. And we have standards that address both proximate and root cause. Talk about sharing responsibility. OSHA on a multi-employer work site will cite two contractors for the same exact exposure. You have an direct employee who's exposed, you're the GC, you have control over the working conditions generally. If we can establish constructive knowledge on the part of the GC to the conditions that your direct employees are exposed to, we can issue citations and defend them. Let's see. Talking about employees' responsibility to an event that they've been the victim of. Employers do raise the employee misconduct defense, where if they can, present a convincing argument that the employer took reasonable steps to control the hazards on the work site, that that particular employee's act was an act of misconduct, and although we may try to cite that and try to defend it, typically those cases are not upheld by judges. Those citations are not upheld by judges. Let's see if I had another note here. I can't even read my own writing here. So, OSHA's citations and our penalties are not outcome-based. All right. I've been doing this for almost 20 years. I've been the head of enforcement for 3 years. I was a supervisor for 5 years, and I was a compliance officer for 5 years. And I had some other jobs in between there in OSHA that are not interesting to talk about. I have gone onto construction sites or factory sites, general industry work sites, where fatalities have occurred and not issued citations. I have gone onto the similar sites where fatalities have occurred and issued what we call serious violations that carry a maximum $7,000 penalty. I've also gone onto sites where fatalities have occurred and issued willful violations, where the intent of the employer to not comply was the primary issue there, and issued $70,000 violations. So we don't evaluate whether an employee. Let me rephrase that. Our citations are not meant to compensate victims' families. There are other remedies for that, which we've been discussing here at great length today. Our citations are meant to deter other contractors and other employers from violating the law. There's only 1,600 OSHA inspectors in the country. I mean, everybody knows these stats. Shout out to Jacob for saying that our budget was too low. It is too low. Thank you for that. Write your congressmen, people and senators. So our methods for trying to get people to reduce risk on this is I'm backing into my point here. Our methods for reducing risk that dovetail with 241 are deter employers from taking these bad actions, failing to train people, telling their employees to take risks, developing strong safety and health programs that require, it was Bud, I guess, who made the comment about leadership. You know, I have a joke in my office. I say the fish rots from the head. If the leadership of the company, the leadership of the regulatory agency is not effective, then we can't expect the foot soldiers to be effective. So we do put the onus very strongly on the leadership, on managers at construction sites. I had a couple other points I wanted to throw out there, but that's good for the moment.
Okay, so Stephen, I'd like to ask you about New York's safety violation rate with respect to the rest of the country. Where do we stand?
Yeah,
And also about our injuries and fatalities, where do we stand?
Okay, well, fatalities, I actually ran some reports, fatalities related to scaffolding. Just in FY11 and 12, I couldn't get data for New Jersey for some reason. Whoever said BLS data stinks is right. That's just my opinion. It's not the opinion of the agency. But in New York, just related to scaffold-related falls, we had 9 in FY11 and 12. That's October to September 30th of 11 and 12. In California, which is a state plan state, which means that the state of California has their own version of OSHA that regulates in the private sector, 12 fatalities related to scaffold-related falls. Connecticut only had 1. Maryland had 2. Illinois, which there were some comparators made to New York and Illinois, I only had 2011 data. They had 4. And Texas, somebody had made a comparison to Texas, had 12. Interestingly enough, the fines assessed by OSHA in some of those comparator states were similar. New York, 451G1, which is the OSHA standard duty to have fall protection working from scaffolding, $2.7 million in violations for scaffold violations, $2,800 per violation. New Jersey, the same scaffold violations, $3.5 million with a $3,500 per citation.
Wait, you say New Jersey was higher?
New Jersey had a higher, yes, in those years, higher penalty amounts.
Oh, okay.
Yeah. So your tort laws don't necessarily reflect the same economic impact. I mean, there's not a direct correlation between the tort claims necessarily and OSHA violations, for what it's worth.
No, but you said that our safety violations in New York with respect to these other states were what? Same level or lower?
Higher than Connecticut. Connecticut coming in at 1 million for that standard. Massachusetts 2.5, New York 2.7 million. Illinois 3 million, New York 2.7 million for scaffold violations.
Mm-hmm.
So now, in my world, we compare, in OSHA, we compare Region 2, we compare ourselves to Region 5, which is Chicago, Illinois' region, because we have a very similar industry profile. We have big cities with a lot of granite, so they do a lot of high-rise construction there. Underneath, so they can support high-rise construction, so we often compare ourselves to Region 5. So I think that's a great comparator for OSHA purposes.
If I can compliment OSHA, in New York City, they do break it down union, non-union, and for the last 5 years, the 75% of the fatalities in New York City have been on non-union job sites, 10 stories and below.
And the interesting thing is we did a lot of comparisons as a result of Sandy-related fatalities, Hurricane Sandy or Superstorm Sandy, and we found that the correlation. I'll give you the bottom line up front. If you're a temporary or immigrant worker or day laborer who works for a company of 15, non-union company of 15 employees or less, your chances of getting killed on the job are like 15 times your chances of getting killed on a job if you work for an established contractor, union shop with more than 15 employees. Let that guide where we should be putting our efforts to raise awareness at grassroots and state and community level, religious organizations that reach out to the community, day laborer groups, immigrant groups. These are where we're finding the most vulnerable workers are exposed to the most serious hazards. And by the way, and I think most people in the industry know this, Latino workers have an injury and illness rate in construction double the rate of native native-born citizens who are in the industry. Double the rate. And the disparity is actually growing.
But back to, for a minute, back to the nexus between what's happening in the field, the courts, and then economics. We know that the claims are averaging between 1 and 3 million. The settlements are between 1 and 3 million. We know that in New York, our insurance costs are 2 to 3 times other states. What that means, just so the audience understands, when you look at a project, generally insurance costs historically have been 5, 6, 7% of a project cost when you're financing a project. This 240 anomaly leads to about a 4% increase in insurance costs, 4% of the project value. So if we have a $100 million project, that's $4 million extra. It's a 240 law penalty. $500 million project, it's $20 million extra that has to be found somewhere. Where does that money come from? It comes from financing? Well, you know, when you model deals, the deal itself has to pay off that money somehow down the line, whether it's a rental or a condo. And so the result is a lot of these projects aren't getting built. But it's a nexus between what's happening in the field, in the courts, and economics. We're paying a lot of attention to what's happening in the field because of this law. I want to give you some basic facts of a case that we're watching right now. It happened on one of our projects, Union Project. Actually, it's a hospital we're building, so everyone knows we're being very careful. Plaintiff was an experienced iron worker. He testified that workers must be tied off at all times. He testified that when he began work at the site at this time, he was provided with a harness, a lifeline, retractable to tie. He admitted that mandatory orientation safety training occurred. He admitted that he signed the orientation manual. He testified that there were regular inspections at the site. He was observed utilizing his harness and his retractable in another area just 15 minutes before his accident. The retractables were brand new. The plaintiff testified that all decking must be secured before he could step on it. His job was to lay metal decking to form the first floor of the building. He testified that he was given metal decking as well as fasteners. He ended up apparently not stepping on something that wasn't fastened, and he fell. And it was clear after he fell that he didn't have his harness on and he wasn't tied off. Now, of all cases, there are 2 defenses in 240. One of them is sole proximate cause. It's the best case we've ever seen in field, sole proximate cause. He caused the accident. He caused the accident. At least we'd like to argue.
Wait, how did he cause it if it wasn't fastened?
Because he wasn't tied off. He didn't follow the
He wasn't tied
instructions.
off, but then there was something loose that he stepped on. It's not
couldn't
exclusive, is it?
Part of what he was instructed to not do was ever step on something that wasn't tied off, that wasn't fastened.
Why wasn't it tied off?
Because he hadn't installed it yet. And part of his job was to install it and fasten it, and then he could step on it.
May I
So
ask?
let me finish.
Sure.
So we moved for summary judgment. And again, we're watching this because we see our insurance costs go up. We see our insurance costs go up by millions and millions of dollars. Sometimes we have to lay people off because we can't get jobs that are a big issue. So we moved for summary judgment to just, we'd like the opportunity to argue that this person contributed to his accident. Not only did we not win that argument, but they won their argument. We lost. Now it's all about damages. The whole trial is going to be about damages. And the check will probably be in the 7 figure. It'll be whatever it is, $2, $3, $4, $5 million. It's another example of why this is a bad law.
Mr. Kaplan wanted to say something?
I just had a quick question. So you're saying he was doing leading edge work that required him to be tied off. That's what he was doing. He was doing leading edge work.
I don't know if it's leading edge work. I don't know.
But it was something that the policy was to be tied off because he was approaching unsecured areas, or something to that effect.
Something to that effect.
Okay. I just wanted to get a clarification because I wasn't sure if that was clear to the audience if that was what was going on because I'm sorry, it was Elizabeth. Victorine.
Yeah.
Had asked. I'm sorry. Had asked.
Yes, that was
about
the
circumstances.
Yes.
Can we talk about the recalcitrant worker? It seems very, very confusing as to when that may apply and when it won't.
It is. It's impossible to prove.
It's not impossible to prove. Actually, recalcitrant worker is almost a misnomer now. Back in the 90s, prior to the decision in Blake, it was basically the only way to defend a case to show that the work is recalcitrant. But now, in the 2000s, the law has changed, and the law has changed. 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 And the la But the definition of sole proximate cause is broadened with Blake in cases after Blake really subsume recalcitrant workers. So as a practical matter, defendants will argue sole proximate cause because it's just simply easier to make that standard. And if the facts were, as we just heard, that he had a harness, he was told to use the harness, he had no good reason for using the harness, and that was the only cause of the accident, that's a defense. Either those weren't the facts or the court misunderstood the facts. Either way.
We have judges that are expanding it. I mean, that's part of what the problem is with the statutory framework. The judges are applying it the way they want to apply it because they have so much latitude.
But
that's the reality.
I don't know how much latitude it is. It seems pretty clear. Here's a three-pronged standard. We apply it. Of course, in any standard, that involves fact-finding. What is readily available, how far away, that could differ in one judge's estimation, what readily available means in the context of that, or what is no good reason. But the standard itself is clear. And if that standard was met, you had a good defense. Maybe the facts were a little bit different or the judge misunderstood them.
Or we had a bad lawyer.
I wouldn't just say that it's not just bad lawyering, but what happens a lot of times is, I'm dealing with these summary judgment motions all the time, and you have to put, if the judge is going to make a decision, you have to have actual evidence, and oftentimes they don't put in affidavits from the appropriate people, or they don't get the deposition testimony that they wanted to from their own clients, and then the lawyers just write in, well, this is what the facts are. But as lawyers, we all know that what a lawyer writes, that's hearsay affirmation, that's not admissible in court. So part of the problem, oftentimes, is that they don't get the admissions that they like from their own clients. There may be a reason, not that they're trying to avoid their lawyers, but they can't offer what their lawyers want to submit to get a defense, because it's not always the truth. So you have to then improvise, and you just put in an attorney's affirmation, you say this is what it is. But if you don't have evidence of that, you can't fault the judges for applying the law.
Okay, so before we break to question and answer, I just wanted to ask you about the unwitnessed accidents and the liability in that area. Has there been a
It's a great
trend?
question. In the strict liability context, they win. Unwitnessed accidents, height related, they win. We write checks for our deductible, by the way, is $1.5 million in some of these policies. So we write deductibles, $1.5 million goes right to the unwitnessed. I mean, this whole thing makes it ripe for fraud. It really does.
And what about the workers' comp, that exception for the grave injury? Is that brought up the cases?
Well, it exacerbates the general liability problem, right? Because there's less opportunity to tap the 1B section of the workers' compensation policy post the workers' comp reform. But really, the whole, it goes back to this whole system. We've heard here today from some of the panel is this is about safety. And so we are the only, back to the beginning of the conversation, we're the only state with a statute. Somehow the rest of the country has figured out how to operate safely in union and non-union environments.
And maybe the contractor doesn't have to exercise care because 90% of it will be the plaintiff. They'll avoid 90% of the liability. This is an incentive to make sure that doesn't happen. Of course, the incentive is blunted if, as Mr. Collette noted before, it ends up that everyone is paying for the mistakes of a small segment of the construction industry. It would work better if it were priced as he suggested.
Isn't the fairest result there that a jury decide how much of it is the fault of the owner and general contractor for the plumbing contractor drilling a hole and then leaving the room within minutes, and how much is the fault of the plaintiff for not moving that box? He's got an otherwise perfectly working A-frame ladder, for not moving that box to make sure, I do some work in my home, I'm a lawyer, but I do get up on ladders every now and again. I make sure that the 4 legs are clear in the area that I'm putting down. How is it that the best result in that case is let a jury decide the percentages between the plumbing contractor, between the owner general contractor, and between the plaintiff? I'm not going to get there, Brian. You know that. I'm going to lose on summary judgment. How is that not the fairest result? The result I suggest.
There are 2 things we're looking at. 1, fairest result, or 2, from a policy perspective, reducing the incidence of accidents in the first instance. That's the primary policy of 240. It's not really based on fairness. It's reduced, it's based upon a legislative attempt to reduce the incidence of accidents, of deaths in the first instance. And it's also a recognition that at other sites, I could go through other cases.
So I have to tell my clients, though, this statute is not about fairness.
No, it's secondarily about fairness. It's about trying to save lives. It's about trying to save, in an industry that's difficult, in an industry that's inherently dangerous. And that's what it's
Thank
about.
you.
Excuse me,
Supervisor
Brett.
making sure that people are doing their
Thank you,
job?
Brett. The man in orange would like to speak. We don't have all day. I hear your point. It's a good one.
My name is John
Sorry.
Rappaport. I'm
Yes.
the general counsel for Component Assembly Systems, a wall and ceiling contractor you might know of. We have offices in 7 states. I wore my high visibility sweatshirt.
The man in orange.
To the job site after this. We actually came up with this so we didn't have to move in those vests. And we could be more productive on the job just wearing this rather than a vest, which you have to wear now. So part of it is innovation that you want to see from construction companies saying, hey, our guys can be more, or women can be more productive like that. And I have some extras if anyone's The point, or hats, we do hats, so we got to. But the point is that we employ 800 carpenters in 7 states. And in New York, I can tell you, public policy is hurting us because we company men and women that, we employ 100 company men and women. How about the other 300? We see an incident where they know they're going to get laid off, and all of a sudden there's people laying down, not always, because they know they're not going to be rehired anyway, and they know they have 2 bites at the apple. They got the workers' comp bite, and then they got the third-party lawsuit bite. So the public policy is encouraging workers to do, this fraud adds up, $20,000 case, $50,000 case. Don't forget the insurance companies settle these cases. They don't go to trial. And our GL policies go up because we have 100 cases, not just the amount. New York is the worst state because of they have a second bite at the apple to get an additional money beyond workers' comp. That's what's wrong with this. It's not that we want to save lives, but by giving them this ability to go third-party lawsuit against their employers, a lot of people end up, all of a sudden they're getting laid off, and we find cases where they knew they were getting, or felt like they get laid off, and next thing you know, there's trips and falls and all kinds of stuff in New York, not in the other states that we track. Does that make sense to everybody?
It doesn't seem, though, that you're talking about a 240 problem. You're talking about a lawsuit problem.
The only way to get a third-party lawsuit is to go over the threshold, 240, 241, where you can now sue your employer through the GC. Remember, subs get hit the worst on this. We always love the GCs and Gothams and all that, but we're the ones paying the biggest price. We don't have the money, and all those lawsuits are on us, only in New York. So why should that be as a public policy matter to give them 2 opportunities to then sue your employer through GL? That is wrong. It's the wrong public policy. And until we change it, New York is the worst state. We're not the Empire State anymore. We're the lawyer state, and I'm an attorney. So I'm tired of this nonsense. Thank you, and I'm safe today.
Yes, go ahead. Beside you.
Question for Mr. Kaplan. You said you kind of compare yourself to Chicago, and it's kind of more comparable. How do we compare from a safety standpoint to Chicago?
I mean, that's a really, really broad question, but I will tell you that, well, I mean, we can talk about, well, we have a threshold called egregious and significant cases. These are cases of high penalty amount or significant for other reasons. And Region 2 issues maybe 1 or 2 egregious cases every couple of years. And Region 5, they seem to issue 4 or 5 of them a year. Now that could be because their solicitor's office, their attorneys are more relaxed than ours are because they're in a less litigious environment out there. But it seems that for all practical measures of injury and illness rates, We're very similar to that. So the injury illness rates in let's say Chicago versus the injury illness rates in New York City in construction, comparable.
The law's not doing us any good. All the money we pay for is not doing us any good.
Well, I don't know about that.
Well, excuse me.
By the way, that's not true. You're saying a full-
Excuse me. You asked a question. I'll answer two statistics, okay? One of them's right in front of me. From 2010 to 2012, New York had the 6th lowest construction injury rate in the country, despite what I think most people who are reasonable would say is potentially a much more dangerous construction
Where are you getting
environment.
that from?
That's from the Bureau of Labor Statistics.
Okay. So,
New York was, Illinois, which repealed its Scaffold Law in 1995, had an injury rate of 5.9 per 100 workers. New York had an injury rate of 4.7 injuries per 100 workers. That is a statistically significant difference in favor of New York being a safer construction environment. And since we talk about economics, we ought to at least talk about what most people think is an important economic indicator, which is job creation. Illinois repealed its Scaffold Law in 1995. From 1995 to 2012, it lost 35,000 construction jobs. New York, which is supposedly under the incredible yoke of the Scaffold Law and can't do anything right, gained 60,000 construction jobs. Now, the only reason I bring that up is because opponents of the Scaffold Law so frequently say Illinois is such a great example, and we want to follow what happens in Illinois. Number one, that's a rather silly economic comparison, but obviously, there are other things that drive economic performance besides the Scaffold Law. But if that is the argument that opponents of the law want to make, and they have made it, it's not even wrong on the narrow grounds that they have made it. Illinois right now is, by most measures, an economic basket case. It has one of the worst economic environments in the country. And in construction, it is dramatically trailing New York. So anyone who wants to look at scaffold law and non-scaffold law and just look at simple job creation, we are trouncing the state that is most often cited as the thing that's the best evidence of why we shouldn't have a scaffold law or why we should change it.
yes, thank you. Did you?
I'm sure that a lot of variables go into these numbers, but the numbers that I see on Illinois, or that I've seen after it was repealed in '95, the number of construction employees went up 28%, fatalities went down 30%, injuries went down 53%, and the carrier lost costs went down 90%. Those are the numbers I've seen. I'm sure that they're biased, but
Anyone who wants to get the Bureau of Labor Statistics, the official place where we calculate construction employment, happy to send this to you. The Bureau of Labor Statistics says Illinois lost 35,000 construction jobs from '95 to 2012 after repeal. New York gained 60,000. That's not my statistic, that's the U.S. government.
Thank you, but I think there was an issue about the accuracy of those BLS statistics raised this morning.
There was,
But,
the issue was that the opponents of the scaffold law stopped their calculation after about 2 or 3 years, and in some cases, they extended
No,
to
I
2006.
think Professor Bentley mentioned that. There was a question about that. But anyway, did you have a question?
I had a question. I'm counsel for a member of the state legislature, and I have been in the state legislature in that role for 10 years. And I should be in Albany today because there are intense budget negotiations, which many people know. But I decided to come down here because this conversation has been happening for the last 10 years that I've been here and before.
Well, thank you.
And I thought that this morning that I would come away from this conversation with some idea of what the parties on both sides could offer to the legislature to do. But it seems like there's still this gross tension. There are policy concerns about keeping people safe. There are policy concerns about economics. There are policy concerns about not eroding the value of the law as it has evolved in New York State primarily. We look to other states, but we're very, very, very pragmatic about New York State being a leader. So those others influence, but they do not direct what happens in New York. And I say that from a legislative perspective, not being elected, but working in that area. So I encourage everyone up here to really help influence what the policymakers are doing. Moya's bill, typically known as a sunshine bill, to broaden what insurance industry is supposed to offer the general public so that decisions can be made, is the only thing that I've seen in the past 10 years that's a step in trying to find some remedy. I cannot reiterate how important it is for you all to bring down the temperature a little bit and really try and produce something that the legislature can work with. Because it's not that we want to ignore safety concerns. My God, no one would ever, an election year or not, no one would ever say that they want to ignore safety concerns. But economics is an issue that can't be ignored. I don't have anything more to say except just give us offer something as a remedy.
But the question, the fundamental question to me is, for being outside the fray, is does the Scaffold Law 241 make a workplace safer or not, right? And if there, to my mind, if this is my opinion, not the opinion of the federal government, to my mind, if there are other laws that functionally cover the same ground that are duplicative, then why have two laws on the books?
Because they're not duplicative.
Well, I don't know the answer to that. I mean, I'm just.
What two laws are you saying duplicative?
Well, if there are requirements on the New York State law for how to set up a scaffold, how to train employees on how to work with the scaffold, how to have competent persons on the scaffold, or directing the erection and disassembly of that scaffold, those 3 points are covered directly by OSHA.
Exactly.
In a federal law.
Exactly, and they weren't around in 1885.
Right. So my question is...
You know, we're skyscrapers.
Regardless of that, my question, to throw it out, is conceptually, why have two laws that overlap?
Steve, I think that's an excellent question, but I think it also relates to, there are two very different issues that we're looking at. One is, what standards should you follow at construction sites where you get involved, where OSHA gets involved? And the other, which is what we've been talking about most of the morning, is what to do from a tort perspective about imposing liability. The first issue, the standards at construction sites, it's a real anomaly. It's very curious, because in terms of the courts and in terms of labor law section 241 subdivision 6, we haven't been talking much about that. The courts only care about the New York State standards of Rule 23, which no one at construction sites knows anything about because they don't care about because they follow OSHA. Our state standards, Rule 23, have been moribund for decades, whereas OSHA is an evolving and enforced standard. And one thing that we had talked about, not here but in other places, is changing the focus of 241 subdivision 6. That's the statute that basically says the plaintiff has to show there was a violation of a concrete safety regulation. And if plaintiff shows that, which was a proximate cause of the accident, plaintiff has a cause of action and comparative negligence is a defense, section 241 sub 6. The idea is to key that, instead of to the state regulations, to the OSHA regulations, which are actually the regulations that are used at the site. And so I've not heard a good argument actually against that. Why have these usually overlapping, sometimes conflicting standards where the OSHA are just so much more complete and more thought out and more enforced?
Thank you, Brian. I'd like to mention to you that in closing, we will close with Judge Smith, but in my review of a lot of the case law, when the Court of Appeals either expands, interprets, or contracts, or asks for guidance from the legislature as to whether it's going too far, the legislature doesn't seem to respond. Usually they tend to go with what the Court of Appeals does. Amendments have followed the Court of Appeals precedent, but when the Court of Appeals asks for guidance as to whether they're going too far, the legislature has often seemed silent.
The legislature is not
I understand that, but
of intellectual capacity. And so when the industry is this divided and this tense, it causes stagnation for those who would write the laws to govern. That's why I say we gotta offer something.
okay, and with that, let's close with Judge Smith from the Court of Appeals.
Hey, can I mention something real quick? I'm kind of an oddball here. I'm a union contractor, general superintendent, and it just sort of becomes obvious to me that you have lawyers trying to solve a situation where they don't really understand what they're trying to solve. and this is just me just looking, because I've been in the field for 28 years now, and they made a comment that somebody gave him a 30-foot rope and there's a 14-foot fall. The reason for that is the tie-off point is 10 feet higher than he is. I clearly understand that. I know that. The guy who's getting the rope clearly understands that too. He's not going to tie you up on his feet when there's something down low. They said there was an open trench right there, and the guy's backing up the truck. The reason for the guy standing there backing up the truck is because there could be a trench. That's his sole purpose, to make sure that the truck has a safe way to go. And as a union contractor, our flagmen are certified. You're certified flagmen. They're trained people. A construction site, if you've ever been on there, you walk in, there's dirt. Then all of a sudden there's a trench. Then all of a sudden there's concrete. Then all of a sudden there's block. Then there's steel. Then there's a ladder you gotta climb up. Then the point with the metal deck. That guy's job is steel beams. He's putting down the deck to make a platform to pour concrete. He knows what he's doing. He knows there's deck. No, there's no deck here, but there's deck here. He knows that. They're trained people. So you guys just looking at this saying, you know, a guy
What's your
stepped
import
off
then?
a
If he
ladder.
knows that, what is your point?
That they're trained people. So a guy with a labor law on a scaffold, or a ladder, even a ladder, he falls off a ladder one step, he falls off. Me as a general contractor gets sued, and I lose automatically. And I can't afford not having a deductible on my policy. So I have a $500,000 deductible. I just gave $500,000 away because a guy stepped off a ladder and twisted his ankle and fell, and now he's suing me, and I have no defense. And it's so frustrating. Our company now, right now, is finding out ways not to hire employees on our payroll so we won't get sued. So there's companies out there right now where you can hire labor through a third-party person who hires people, so I don't get liability. It's insane what's going on.
Sir, nobody's
Okay.
getting $500,000 for a twisted ankle. I promise you.
Thank you.
Okay, I've been given the assignment of closing this vigorous session. And I guess I'll try to close it on a note of humility. As the last speaker made the point that maybe the problem is lawyers don't know what they're talking about, and I often think that that judges don't either, and that it's obviously very frustrating for people who work every day in the field to try to make judges or lawyers or legislators understand what's really going on out there, especially, and of course part of the problem is that what's really going on depends a little bit on who you are and what your interests are and what you think, and the guy across the table may think something else is going on. I was very disappointed to hear that our decisions did not violently move insurance rates one way or the other, but I'm not terribly surprised. There's only so much we can do. We've got a statute, an unusual one, one that a lot of, I suppose I could go out on I should go out on a limb. That's an elevation-related risk. But I will, I may take the liberty of saying it's hard for me to imagine that this particular statute, with all its features as they exist, would be passed today if it didn't exist. But there, that is among the many things that my court has no control over. We try to cope with it as best we can. We worry about what it says. We worry about why it's there. We worry about what we said last year, and we worry about what we think is going to produce a better result. And we probably we decide a lot of cases, and we probably do not have any tremendous effect on the universe. There's a basic. There's obviously, from anyone who's been in this room knows, there's some rather intense division fueled by very strong opinions and very strong interests on both sides. I'm sure our friend from the legislature will tell us that's not a great recipe for getting legislation through. That's a recipe for the status quo. And I guess the people who like the status quo continue to have an advantage, and that's all I can tell you.
Thank you very much.
could go into the Guinness Book of Records to have a panel that size. The Building Congress, for those of you who don't know us, was formed in 1921 to bring the industry together. And after listening to the discussion we just had, I think we need to bring ourselves together quite a bit more. We have a number of you I know are members of the Building Congress. We're a membership organization, and we have a very active program serving the industry in New York City. And we focus on things that the industry agrees on. We don't get into issues like the Labor Law 240 too much because the industry is so divided, and we have members on both sides of issues like that. I also wanted to tell you that spring begins in a week. I came over here, I walked 3 blocks, and I didn't think I was going to make it, but it was this will change. I welcome the opportunity to talk a little bit about the New York City construction market. It is a very healthy market right now, a $32 billion market. We're getting back to the peak. The peak in 2007 was also over $30 billion, and if you account for inflation, by next year we should be in the $37 billion range. Now this is real work. I mean, there's a lot of things going on, and we're part of the world's largest metropolitan economy. New York, New Jersey, and Connecticut generate a gross regional product of like $1.5 trillion. This is big business. We are bigger as an economy in tri-state New York than about, except for 6 or 7 countries of the world. I mean, it's definitely big business. And you ought to consider just how interconnected and indeed how fragile our economy is. Witness the impact of Hurricane Sandy, just the gas explosion up in East Harlem yesterday. Things can impact a large and very diverse and interconnected economy in many different ways, and I think it's becoming more and more apparent. When I look at the construction market, though, and I look at the economy of New York City, I see a lot of reasons for optimism. We have a lot of things going on here that can reassure us that we have a pretty bright future. And one of the reasons why this issue of Labor Law 240 is such a contentious one is the stakes are so high. You know, the old saw about in academia, why do faculty members fight so much? Because the stakes are so low. Well, in this case, the stakes are high. One reason for optimism is that New York City is a global leader. It's a global leader in communications, in finance, in culture, medicine, education, technology, and indeed we call ourselves the capital of the world because we have the United Nations. It always troubled me that people get upset about parking tickets that members of the UN don't pay. This is a city that gives away 80 to 100,000 free parking permits to people, and we worry about a few parking tickets from the UN when the UN is so important to us going forward. But being a global leader like we are leads to lots of economic activity, and that economic activity reinforces itself in so many ways. A second reason for optimism is that our economy recovered and is recovering from the global recession, the Great Recession of 2009, in very smart ways. We have more jobs now than we've ever had in New York City. It's over 4 million jobs. Now, they may not be as high paid in many cases. Many are tourist related. They're more lower wage jobs, and there's a lot of public policy debate about that. But we have more jobs, more people working in New York City than ever before. Another reason for optimism is that construction is at an all-time peak, as I mentioned. We have Many reasons for that. The residential market has come back very strongly. We have hopefully something like 18,000 new dwelling units, maybe 20,000 this year. It was about 18,000 last year. That's not the peak that we had around 2005, 6, and 7 when we were over 30,000 units a year. But there are a lot of high-end units, and it's an upward trend. And the market collapsed from 2008 to 2009 from 30,000 units to 6,000. So coming back to 18 to 20,000 units is a very smart rebound. But the areas of strength are institutional spending. All the healthcare, higher education institutions have capital programs. We're building a lot of school seats. The School Construction Authority remains one of the most active parts of a strong New York City capital budget. We have office development now reoccurring, not just in the World Trade Center, but out at Hudson Yards and elsewhere in the city. So I think you can look at this construction market as one that is not going to fall off the cliff in the next year or two. We see no end in sight to a strong construction market. The major projects underway at Hudson Yards, Atlantic Yards, the World Trade Center is a source of reassurance going forward. And a strong capital program by city and state agencies is also giving us a lot of confidence. The thing to remember about public construction in New York is that it's a shared responsibility. There's no single agency or no single level of government that directs our $18 billion a year infrastructure program. It's shared among the federal, state, and city governments. And this is, it's important sometimes to really a source of wonder to me that we get as much done when no single person or level of government is in charge. I mean, some of it is the responsibility of the mayor, to be sure, but a lot of it is the responsibility of the governor, and some the president of the United States. Another reason for optimism is our reliable energy. Despite the impact of Hurricane Sandy, Con Edison is still the most reliable by far utility in the country. That's because so much of its network is underground. And we saw in the Hurricane Sandy results just how fragile that can be with extreme storms. But in most cases, it's a very reliable power source and a real advantage for us compared to some of our urban competitors around the world. Another reason that I'm optimistic is that we still have a very safe and a very secure environment and a well-managed city. This is something that has been increasing over time. Under Bloomberg in particular, the Bloomberg administration had 12 years of very effective city management. And crime and safety were improved in the Bloomberg years at a steady rate. And just the first couple of months of the de Blasio administration, crime went down even further. So there's a lot of good news there, and when people feel safe and secure, they do invest, and they do live here, and they do visit here, and that's very important. We've improved the environmental quality of the city immeasurably in recent decades. And now, in recent years, we're even retrofitting older buildings so they're more resource conserving than before. So finally, you can just see what people are voting with their feet, that more people want to work here, live here, and visit here than ever. And this has given us lots of reasons for confidence. But with all this optimism, what are the challenges? What are the things that we should be focusing on as things are going as well as they are? Well, changes in government. We have a new mayor, a new council speaker, a new controller, and they have dramatically different priorities. And how they're going to play out against this backdrop of success. against this backdrop of so many things working. Already you see the new mayor is focusing on a few things. And he's not really paying much attention to some of the things that made the city as strong as it is now. That doesn't mean he won't. His first capital budget was a strong one. We were encouraged by that. He said the right things about the economy. He said he's going to pursue the East Midtown rezoning, which is so important. But he's not yet really done much in those areas, and he hasn't appointed a lot of the key commissioners, like in Department of Buildings, has not been filled yet. So the jury is still out on what the changes in government mean for this optimistic picture that I just sketched for you. And of course, past success doesn't mean we're going to have future success. When you look at some of the things that are making the city as strong as it is, they may not be continued in the future. From a construction standpoint, we're still by far the highest cost construction market in the country. And we can't just assume that organizations are going to build here because we have other strengths. That we do have to address costs. And everything is, to me, on the table. The insurance costs that have been increasing allegedly because of Labor Law 240, they need to be addressed. The work rules, the union work rules that lead to higher costs need to be addressed. The fact that logistically it's very hard to get supplies and materials into job sites. We have to find ways to ease some of those. And finally, the cost of government in a construction job is higher here than any place in the country. All the reviews, all the procedures that are added to the cost of a project need to be addressed, and if we're going to have the kind of strong construction market we've had in the past. Infrastructure renewal is very uncertain here. The Port Authority just passed a very strong $25 billion 10-year capital program, but the MTA's program is not funded after this year. And the outlook for the New York City capital budget is one of less spending in their 10-year outlook. So we can't assume that our infrastructure is going to be kept up. A report was just issued earlier this week that said that we've got a $47 billion deficit in infrastructure just in New York City. So there's a real challenge there. We have very uncertain development prospects. 94%, right now, 94% of all office construction is just in two places, World Trade Center and Hudson Yards. That's not a recipe for a global leader to regenerate itself. We need new places for office construction, like the area around Grand Central. That's why the East Midtown rezoning proposal is so important. So this uncertainty is, I think, one of our biggest challenges. Unless we can identify and facilitate office construction in the right places, I think the city's future prospects could be dimmed. And finally, our shifting public priorities. We're shifting away from the built environment, at least from what our leaders, our newly elected leaders are saying, away from physical built environment kinds of issues towards social issues. Now, both are important, but how do you build and sustain and grow a great city? You don't do it on a social agenda alone. So where do we go from here, and who needs to do what? I think we need more of a common agenda among design, construction, and real estate interests. We need to bring people together. The panel, this large panel, those kinds of issues, we've got to resolve those. And we've got to focus on what got us to the strong point we're in, and to make sure we carry that forward. Government, I think, has to be much more proactive in supporting private institutions in their development programs, like NYU, Columbia, the major hospitals. We should be facilitating their efforts, not just standing and letting aside or more than that, getting in their way. Third, I think the administration and the council should continue steps to spur office construction, not just in Hudson Yards and World Trade Center, but in other places, like I said, like Grand Central. And finally, we need more dedicated sources of revenue to fund our infrastructure programs. The establishment 30 years ago of the Water Board that take water and sewer revenues and dedicate them to water and sewer projects has been a real shot in the arm for environmental facilities in this city, and it's really helped the city's capital budget to have that money directed to construction. So anyway, that's how I see the overview. There's a lot to be confident about, to be impressed with, but we certainly have an agenda of unfinished business. New York City is at its best when we work together, and I think we need to do that in many ways in the years ahead. Thank you very much, and I appreciate your attention. I take questions.
Excuse me, could you tell me a little bit more about the Building Congress, the organization?
The Building Congress is a membership organization, private, 501c6. And in many ways, we're an organization of organizations. We have associations, we have labor unions, construction, architecture, engineering. And it fashions a program to do a lot of networking through committees and events, but then we're an advocate.
I was going to say, is it like a trade? Is it like a...
We are a trade. I like to think we're a hybrid between a trade association and a public policy organization.
Do you actually propose legislation and so forth?
We've got several bills in Albany now, one on emergency responder bills. We're strongly in favor of design build legislation. We'd like to see public-private partnerships enabled through new legislation. We've got about 4 or 5 things that we're getting behind.
How old is the organization?
1921. I haven't been there since then. Terry? Well, I think, yeah, it's a very good question. This cries out for compromise. And the reason it cries out for compromise is that everybody here has a stake in this issue being addressed successfully. Obviously, the labor unions, they don't want to see work. If this is jeopardizing work and holding back work, that their members are losers. Contractors are losing work if so much money is going to pay for insurance or projects don't go forward. Public agencies like the School Construction Authority are not building as many seats when they pay this much money for insurance. So you can go through, everybody loses in a situation like this. Now, so how do you compromise it? Well, you find ways to address with the insurance companies in particular, the things that are driving the cost so high, and I think you do need to amend the legislation. I don't think repeal would be the way out, but find a way, perhaps on a trial basis, to appeal it. I know with the Wicks law, thresholds were put in. I mean, the Wicks law was one that everyone said, just like this law, you can't change it. You know, sides or people have really dug their heels in. But we found a way to amend it, and the School Construction Authority was given an exemption. Well, maybe School Construction Authority should have a trial, a temporary exemption from Labor Law 240, and just so you go to the other comparative negligence standard on a trial basis. Let's see how it works. But we've got to do something. And what the Building Congress is doing is putting together a background paper trying to address all sides of this issue. We can't take the lead in recommending a solution yet because we've got members on all sides of it. Yes, sir.
Thank you. And thank you for the presentation so far after lunch here. I was wondering, could you characterize for us anybody or the parties that you believe would be opposed to any change whatsoever in the labor law 240? Are there any parties such as that out there? And could you characterize them for us?
Well, I heard some of the legal representatives sound like they didn't want to change anything.
I didn't know if I could respond, but I was wondering what are their interests?
Well, I think other people could answer that. Well, I think the view of trial lawyers is that this leads to more cases for them, and that's why they like the law the way it is, because it's been fairly lucrative. But if they could be convinced that the law could be changed and they wouldn't lose work, that would be an avenue to pursue. But we're still going to have, I think, legal remedies if you have a new law or new procedures. I mean, there are always legal remedies. So I really sense that there's a way out of this, but it's going to take some real tough negotiations. But the reason that it's gotten, I mean, one person said, oh, why hasn't this come up before? Well, it hasn't been so expensive before. I mean, it's gotten to the point, I didn't hear the beginning, but I think the School Construction Authority, probably Ross Holden probably mentioned how expensive it's gotten just for his agency. And there are a lot of other agencies and employers that are paying so much for insurance, if they can even get it.
I get a sense that a lot of people in the room don't really understand the pain that contractors are having when they're being told either they can't buy insurance or the insurance they can buy has exclusions which are totally unacceptable, or the cost of the insurance is so expensive, especially given their background, that it threatens their solvency. And, you know, people seem to want to think that that's made up by the insurance companies because they're making so much money. But the reality is, supply and demand, there's only a couple of insurance companies that will even entertain writing construction risk. And I'm trying to put something together now that involves a tower crane. Ain't easy. It's not cheap. But I just get a sense that people don't realize that. And if there is going to be a solution, there's got to be something in it for the unions. There has to be something in it for the trial lawyers, and there has to be something in it for the contractors as well as the owners. And it doesn't look like we're to that point yet. I don't know if you can make any useful criticism of what I just said or add anything to it.
Well, I think what you just said is as a general framework for how to approach the problem is the right one. But for the life of me, what's not clear is who's going to do that. See, because if you listen to the panel, I didn't see where who's going to lead the solution. And that's why we're putting together some people. Maybe we might try to be an honest broker if we can find a way to do that. Because no one's all wrong on this. But the net of it is that it's really holding back the industry. But then you can also see how much work we're doing. And it's like other things with the New York City construction industry has this ability to get things done despite incredible obstacles. Well, this is one of those obstacles, but somehow the work gets done. It's more expensive, it takes a little longer, but it gets done. And that's why there isn't an out-and-out crisis. It's not a crisis of you can't do anything, it's you got to do it. It takes longer and costs more money. Well, so what? So people will put up with it, but that's not the answer.
Just to add a little bit about what you're saying, I'm an insurance broker and I work for Willis, we're the third largest broker. A lot of people are blaming the insurance companies, saying that they're making a lot of money, when in fact, to your point, a lot of them don't even want to work in New York anymore because it's too dangerous. They're just trading dollars at a certain point. You know, obviously the way they make money is by keeping the premiums that are paid to them. And if claims come in, they're not doing that. So a lot of them have removed themselves from what we're going to hear for the next panel is wraps for these construction projects where the owner controls the insurance all the way down to the subs. And that is happening because the subs aren't able to afford insurance, to your point. So from my perspective, you know, the issue isn't necessarily the cost per se, because to your point, it's just the bigger developers, the Silversteins or Vornados and Relateds that are able to put up that money, keep it safe by having a risk manager, and then get their, you know, pay the premium, but then also, you know, throw that cost into the cost of the building, whether it's, you know, retail, condo, what have you, which is why we're seeing, you know, $9,000 per square foot. The real problem seems to be, well, on one side, people want to keep their workers safe, and on the other side, you know, they want to keep the cost down. I don't see how that's mutually exclusive, only in that the trial lawyers want to litigate every fall that happens. So you have people throwing themselves off the ladders or whatever, or you have legitimate falls, but then everything goes to, you know, trial. So I feel like that's where the solution lies, is that you can keep your people safe without having to have such a absolute standard. And that's just from an insurance perspective, so not a legal perspective.
Yes.
Just along those lines, I wanted to just address the idea that the objection to the amendment, you know, and my understanding is that it's just to amend the statute to allow for contributory negligence. The objection is, I think as you understood it, that the cases would go down for trial lawyers. I don't think that actually they would go down. I think what would happen is they wouldn't get extremely expensive settlements as quickly and easily as they get them now. And that is, in my opinion, what is sort of the unfairness, if we're going to talk fairness. As soon as they can make their motion for Labor Law 240 to apply, if they win in the court below, then the interest starts running at 9% against, in my situation, my clients. It's a very expensive interest rate. You can't get it at any bank, I'm sure you know. And if you take it up on appeal, the interest is running that entire time. So my clients are really torn whether the cost of an appeal is worth it when it's merited in most cases. And then if it's overturned on appeal, you're stuck with what happened in the court below at 9%. So the point is, the cases settle quicker and for a lot more money solely because of the inability to argue contributory negligence. Their cases are not going to go away. They're going to be able to take every fall case and file a lawsuit and bring it to court and do what everybody else does, is to try a case before a jury. But we're going to be able to argue if there's evidence that the worker may have been at fault. So that's my
See, the thing why don't we get another question over here?
I just want to make two comments. Number one, the New York metro area is booming, no question about it, it's growing. I just want people to be aware that the rest of the state is in a death spiral, that the population is decreasing, and very bad economic condition in the rest of the state. New York, the city, is a big exception. The second thing is I'm understanding, I've heard that this is affecting, what's it called, MBE programs, minority programs, right? Because they cannot possibly get, it hasn't been brought up, but from things I've heard in Albany, they cannot possibly get liability insurance. So I guess if you can do a wrap, then you can include them, but people are having trouble getting some of these subs for set-asides, right? Because could not get insurance. They're not insurable or whatever. If I can speak to that, I've heard like this.
See, the thing that troubles me is that when you don't have a strong construction market, then this situation can really get firms in trouble. Like upstate, I'm not sure what the impact is, but I'm sure it can be much more of a problem upstate than down here, because here we've got enough money and enough construction power, if you will, to overcome it. It's costing more money, but the jobs still get done. Upstate, it may be keeping jobs from even getting started.
We just have a stagnant economy, though. I mean, it's not, New York's economy is vital, and you know, that's the big difference. I'm not saying that they can agree with 240, but I'm just saying they should be aware that upstate may eventually be the, you know.
Oh no, our construction market is much different than it is elsewhere.
Minority contractors and their ability to partner with, larger contractors to do work. It's critically important that this labor law situation be resolved, because as it stands right now, minority contractors can only do work, not only, but the best platform for them to do work is under a owner-controlled or a contractor-controlled insurance program. That in itself is not the remedy, right? Even if we fix some of the problems for wrap-ups, contractors need to go from where they are today, right, to be able to stand on their own 2 feet and build big larger contracts on their own. So at that point in time, they need their own insurance, right? So this labor law issue is affecting both the larger projects that are what we call wrapped up, but it's also affecting the smaller contractors where they need insurance for their own work outside of a wrap-up, they can't get it. So, the compromise here, you talked about this, you talked about, what is the compromise? We know that in Illinois, they were successful in eliminating the law. They repealed the law outright. But in the state of New York, what we're looking to do is add an element to the law where we can introduce contributory negligence. And for whatever reason, to me, it's been a silly argument. I've been fighting this law for 25 years. 25 years ago, the 240 increment over and above a normal GL case was about $5,000. As we've heard before, the increment above a workers' comp case today is multiple millions of dollars. And it's really not about the insurance companies anymore. The insurance companies have left the state, right? Only what we call the surplus lines markets are left behind to write the insurance. And what they want is their counterpart to write this insurance. And how can it possibly be that minority contractors can afford those insurance rates when the platform for rating it is, I want to get as much as I can get for it. But the bigger insurance companies like the AIGs and the ACE and the Travelers have said, I don't want any part of this. I'm leaving this industry group. And if I do write it, I'm going to apply this very, very large deductible. And I'm going to make the buyer of insurance responsible for multiple millions of dollars. So the insurance companies have insulated themselves from the problem. So it's a real catch-22, and it's going to take a lot of compromise, as you mentioned. But the sooner the better, because we don't have another 25 years of fighting this. The cost of risk has gone through the roof, and there's no more time left.
Well, on that happy note, thanks for your attention.
I've been doing this since October, risk management and insurance. And then I'll just
All right, hi everyone. I hope you can hear me. My name is Burt Wells. I'm a member of the Committee on Insurance Law of the City Bar, which consists of about 36 lawyers all engaged in insurance-related legal practices. The committee has a busy and ambitious agenda, including organizing public programs, conducting analysis of legislation and other developments in the insurance industry, and preparing letters and reports on such matters for the City Bar Association. The committee's chair, Dan Rabinowitz, is in the audience today, and Dan's asked me to express the committee's special appreciation for being asked to help add to today's program. This is panel 4. Congratulations to all of you for being the survivors in an arduous and fascinating day. It's the final panel of the day, and our topic, as Terry said, is risk management and insurance. We're going to focus on wrap-up insurance. And before we get into it, I'd just like to remind the lawyers in the audience that if you are looking for CLE credit today, and there is CLE credit for this particular panel, then you want to be sure to sign out at the end of the program. Give your time, and your CLE credit will be on the way to you. So I'm going to ask a series of questions, short questions, hopefully, and we'll get rapid answers and develop something of a dialogue and interchange about the subject of wrap-up insurance and New York Insurance Law Section 2504, which is making some kinds of insurance unavailable. Panelist Tim Walker is a senior vice president with Willis, a leading global insurance broker, where his responsibilities include all aspects of wrap-up programs. And prior to joining Willis, Tim was the director of insurance and risk for Turner Construction's Northeast region. So he's obviously a man who's had tremendous experience with wrap coverage and insurance in the construction industry. Tim, when a construction project is subject to wrap insurance, who buys the insurance?
Well, essentially, first of all, good afternoon, everybody. I understand I missed the fireworks earlier. Hopefully we can stir some up today. Going back to your question, Bert, essentially the owner is the person who's buying the insurance coverage on every project, whether it's traditionally insured or whether it's insured under a wrap-up. So specifically, there are two types of wrap-ups. There's an owner-controlled insurance program where the owner is the one out there purchasing the coverage. And then there is a contractor-controlled insurance program where the general contractor is the one purchasing the coverage. But ultimately, it's the owner who pays for the coverage.
And that's where the terms OSIP and CSIP come
Exactly.
from. Owner-controlled or contractor-controlled insurance programs. And how many policies can be involved if you have every contractor purchasing their own?
Wow. Well, I would say on average, your typical construction site is going to have upwards of 30, 40, maybe 50 different subcontractors with all different tiers, and then the general contractor and then the owner. So in a traditionally insured setting, you have all these different policies out there, and everyone's carrying their own workers' compensation, everyone's carrying their own general liability, everyone's carrying their own excess liability. And by nature, it involves a great deal of cross-litigation and finger-pointing when there is a claim.
But getting back to an earlier point, so either directly or indirectly, the owner is paying for all the insurance program on the project?
Yes.
All right.
The difference being in a wrap-up, they can easily identify what they're paying for. In a traditionally insured setting, everyone carries their own insurance costs within their bid. It's typically hidden.
Got it. Thank you. Now I'm going to turn to panelist Larry Martin, who's the Chief for Disaster Planning and Insurance at the New York City Law Department. Larry advises the city on a wide range of issues relating to insurance, including insurance the city requires in its construction and services contracts, its leases, licenses, and concessions, and permitting rules. Larry, can public sector entities in New York use wrap programs?
First, hello, everybody. The answer for that is some yes, some no, some maybe. Concretely, as many of you people know, there is a provision in the insurance law, Section 2504, which precludes, or arguably precludes, public entities from doing jobs via wrap-ups. There are loads of carve-outs of that, and I want to tease that out because it matters here. In 2504 itself, the Port Authority is excluded from that prohibition, so the Port Authority can do wrap-ups. I understand the SCA has a full exemption as well, but that's via the legislation that created the SCA, and so they can and they do have a very sophisticated, successful wrap-up program. And then the MTA. The MTA is something of a hybrid as far as the prohibition is concerned, and to my mind, a great test case accordingly, because as to certain types of contracts, it is allowed to do wrap-ups, and as to other types of contract, it is subject to the bar of 2504. So it essentially is one of the, perhaps the only entity that has an experience.
The policies actually issued. Is that how all wrap programs work?
It depends on what type of wrap you're dealing with. Usually a CSIP will work that way to an owner. So when I was at Turner, I was selling CSIPs to owners, and we would sell a fixed rate and say, regardless of the losses you have, the most you'll ever pay is a certain percentage of the volume of the job. Let's call it 5%. And as long as your job grew in volume, you would know what your insurance cost is. If your project was smaller in volume, you'd still know what your insurance is. OSIPs typically aren't that way. There's a fixed premium, and then it's almost like an adjustable rate mortgage. If you have a fixed rate mortgage, you have an adjustable rate mortgage. You always know what you're going to pay in fixed rate. In the adjustable rate, you could save money if the rates are lower. Well, in an OSIP, what happens is if you have fewer losses, you keep more of the premium instead of pay it to your carrier.
So the premiums can be structured so that there's a financial incentive for
Absolutely.
a good safety record for the owner as well.
And a good owner will typically look to share that savings back with the contractors and the subcontractors who are hopefully following safety protocol and helping to get that savings.
Now, do you agree with Joe Hogan that the owner using a wrap doesn't really see the effect of insurance pricing that individual contractors would face if they supplied their own insurance?
I agree with Joe in most states, but not here in New York. In New York, you're actually in the middle of pretty much an insurance crisis. You have a significant spike in general liability costs. I'll give you an example. When I first started at Willis 2 years ago, your average OSIP was going for roughly 5-6% of volume. Now they're going 8 to 10% volume. So that cost is very high. It's now hitting the subcontractors and the general contractors in their own policies. So you're seeing a very broad brush here applied to contractors regardless of their safety records. Their general liability costs are skyrocketing.
Okay. So, Joe, I'd like to turn to you both to maybe you have a response to that as well, but also you've explained that the lower premiums may be applicable to contractors with good safety experience, but does running a safe operation come cheap?
No, it does not come cheap at all. Now, generally, you look at that as a return on investment, right? You're investing in safety on the job for a variety of reasons. One, you're going to see a return in lower insurance rates, which, as Tim just pointed out, is a little bit more difficult in New York because of what we heard this morning. But you're also, in EMR, you're still going to see that on a workers' comp. You won't see it as much in GL because of 240, but you'll see it in EMR in workers' comp costs. You're also doing it because it's a marketplace necessity. Again, in private work, if you're not engaging in this kind of safety, and I was out at Las Vegas last week for the Agency of American Convention, and we talked to a lot of owners, a lot of major private owners. This is across the country. And if you're not working in safe operations, if you're not engaged in that to a large degree, you're not going to be getting work to the degree that you wish. And this is where, it's important to explain my biggest concern with OSIPs and CSIPs is within the context of the competitive bidding laws and the procurement laws of New York State, not so much on their own, because I will tell you an awful lot of my members, where possible, for a lot of reasons, most notably the issue of gaps, and we'll talk about that later, are going to be engaging in CSIPs where they can. Unfortunately, not as many of them can as would like.
Now, to take your point about public procurement just a step further, how are these higher cost contractors going to have an opportunity to win public projects, and how do RAPs affect that?
Well, without the RAP, the cost of safety, and most importantly, the cost that they're paying for insurance, both GL and workers' comp, will be a factor in the cost of their bid. Where you're within a wrap-up program, then those costs are not factors in your bid. You are going to pay what everyone else pays.
Okay. Maureen, is the MTA saving money when it uses RAPs as compared to having every contractor and subcontractor providing its own insurance and charging that up to the MTA? And what's your basis for thinking that?
Well, our basis is what's happening in the industry. I think Tim explained it pretty well when he talked about, kind of what what we budget typically and what we had been budgeting 4 to 6%, and now it's looking like it's going to 8 to 10%. We believe that those percentages are less than what we would be charged through the direct contracts and the chargebacks for the insurance. But then there's the additional transaction costs associated down the road. The fighting that takes place to get the claims tendered. And it's not just a cost within the program that it gets transferred to us, but it's also staff time at each of the agencies. The agency's legal departments get very much involved in responding and helping to handle those. But then there's a second savings component for the MTA. We budget that amount when we go in, but we do loss-sensitive programs, which mean that we take very high deductibles on each and every claim. And part of what we do with the broker contract is to put safety programs in. So we invest a lot of safety resources into the owner-controlled insurance programs, and then that allows us to save on those claims. So whatever we budget, then we know actually what our real savings are compared to what we budgeted. And that's real money to us. So it's well worth the investment in safety. And it's also a great relief to the agency's operating safety departments. They can focus on employee and customer safety, and then we have very specialized construction risk safety experts who are focusing on our owner-controlled projects.
Now, since you're responsible for the MTA's insurance needs on projects for bridges and tunnels where you can't use RAPs, can you tell us about some of the costly problems that you might face without an OSIP?
So what we're seeing over there is we're definitely seeing much higher bids on those projects. Most recently, the last owner-controlled insurance program that we did was the 10 to 14 capital program. We were just starting to see the costs creeping up at that point. Based on everything we've been experiencing and hearing, we're expecting that when we get ready to do the 15 to 20 program, we're really going to see those costs.
5 years. That's why you do 5-year chunks.
Exactly.
2015 to 2020.
Exactly. But what we are seeing is we are seeing on the bridge and tunnel side, those contracts that'll be coming up, we're seeing them, the total cost of the contract. We don't break out the insurance within the bid, so we don't know exactly at that point until later on, but we are seeing higher costs already.
But just sticking for a second with the instance where you have to rely on the contractor's insurance, what about instances where there's a deductible, for example, and a contractor goes bankrupt? Who pays in that case?
Well, we might have to pay. We have very strict insurance requirements for contractors outside of the OSHA programs. And sometimes we seek to get project-specific limits, low deductibles, and that's becoming more and more difficult to get that. And so we believe that's keeping a lot of contractors from bidding on our work because they can't meet the standards that we require.
And then are you finding that that contractors are being subject to coverage that, well, you just said that many are not bidding because they can't meet your standards. But what are the sort of problems you're seeing? Can they get coverage that really extends to everything at hand in the project for you? Or are they facing exclusions?
They're facing exclusion for labor law claims. They are.
So wait, I'm sorry. You mean, so your contractor is being offered insurance to cover a construction job in New York, and the insurance expressly will not cover a labor law claim?
Yes.
Is that what you're saying? Okay.
So.
Right.
So.
Good premium if you can get it.
Right.
What other kinds of problems are you seeing?
And the very high deductibles. So a $1 million deductible by a contractor, what's going to happen in that situation when we get, despite the very, the requirements to defend and indemnify, the tendering of that claim gets more and more difficult when a contractor has $1 million, or an insurer has $1 million deductible. They're going to look for every reason to find an exception not to take that claim. So there's a transactional cost to us then to manage the tender of that, and obviously the ensuing litigation. Unfortunately, when that occurs, I think all parties lose sight of the defense of the primary case, which is, defending what really happened, the damages and so forth, because everybody's focused on the tender.
Okay, so you...
Lorraine, can I ask a real quick question? On the insurance, one, do you look for only New York admitted carriers on the insurance? And two, how deeply do you look at the subcontractors' insurance in those?
I'll answer no, not only New York admitted, but we do look for the subcontractors' insurance. We don't. We require the contractor to take care of that. So what happens is the contractor then, pushes down its requirements. So we do not review their insurance. We're just expecting that it's between us and the contractor and make sure that they do it.
So, in short, you think you're saving on premiums when you've got wraps. You know you're saving on transaction costs and dealing with claims that actually occur, because in the bridges and tunnels context, you see all the things that can go wrong with the coverage there. And in fact, you have a wider range of contractors that you can turn to, not just those that can get ideal insurance, but those of all types.
Yes.
Okay, so let me change the focus a little bit to safety, and there are two safety-related aspects to wraps that I think we should discuss now. The first one's a little subtle, but it relates to a potentially important problem when wraps become the usual method, the daily method of doing business, particularly when a wrap is not just project-related, but is a standing arrangement, a rolling wrap. So I think what we should do is turn to Joe and ask about how that actually plays out in practice here when you have either these rolling wraps or just a customary way of doing business with wraps. So. So the MTA, for example, likes to be able to avoid the intercontractor litigation in response to an accident and worrying about which particular contractor is responsible for an accident that occurred. But is that all necessarily good for the construction industry?
Well, I think that there are some long-term problems in the industry, long-term problems for contractors who put too much emphasis within wrap-up programs. If they don't develop a good insurance relationship, I don't think that that's good for them long-term. At the end of last year, as you heard this morning, you heard Ross Holden talk about the SCA and the potential for losing their wrap-up insurance program. And they'll face a similar issue at the end of this year. Hopefully, we'll all be a little bit more ahead of the curve. But I will tell you that the industry was in a major, and I know the lawyer this morning doesn't like the term crisis, and he liked to use some hyperbole in comparing it to other things, but this was going to be a crisis had they not been able to, because so many contractors had put so much emphasis within that wrap for so long. Had the SCA not been able to renew that wrap policy, you would have seen school projects shut down because there would have been no insurance coverage to deal with that. You would have seen hundreds of contractors, mostly minority businesses, go out of business because they had not developed that long-term relationship at that point in time with insurance carriers. It would have been a real mess. There were real questions about who picks up the completed operations coverage within the wrap-up program. Where are those gaps, and what is it exactly that the contractors need to fill in? And that's not an easy thing to do with projects that are in the middle of a project. All of a sudden, for another insurer to come in and try to write insurance for a project that's already begun. It would have been a major, major issue for us, and I pray that we don't have to face that again at the end of this year.
Okay, well, let's unpack that a little bit. So, so I think that what did these contractors that had only been doing wraps, did they have EMRs? We were talking about a long-term relationship, I think, with an insurer. What is it about that relationship that makes it possible for those contractors to go on and do work outside of the wrap context?
Well, and Tim, frankly, may be able to answer this a little bit better than I can, and others probably in the audience can, but developing that relationship with an insurance carrier is something that is extremely important to the growth and health of a firm. So if someone is doing a lot of work within wrap-up programs, and then they now have to look and get their own insurance, go into and go into the marketplace for other private work to grow, they're not going to have that relationship to fall back on. And indeed, the question of EMR and where the claim attributes and how that affects a particular contractor within the wrap's EMR is sometimes not an easy question to answer. And so let's just take as an example, everyone within the wrap somehow or other was going to maintain a 1. In many, as I said before, in many private sector situations, if you're not below 1, you're not getting the work. And so it really will curtail contractors and subcontractors from growing in some ways. Certainly they're going to grow short-term within those wrap policies because they maybe are doing work that they wouldn't otherwise be able to do, particularly in this insurance climate.
Tim, how does this play out in your experience?
Well, there's a couple of things. I think we're focusing a little too much on the EMRs. And let me just back up a second. Do we all know what we're referencing when we mention the term EMR?
No.
Sure.
How you come up with that.
Sure. First of all, an EMR is like a safety credit rating, all right? So it's an acronym for Experience Modification Rating. And essentially what it is it takes industries by their like kind. So electricians are judged against electricians, steel workers, so on and so forth. And what they do is apply a calculation that says, based on your payroll, these are the amount of losses you should have. And if you have less than those losses, your EMR goes down. By the way, your EMR starts at a 1. If you open your business tomorrow, you have a 1. And over time, if you have less losses than expected, it goes down. So Joe referenced somebody who had a 0.8. A 0.8, the way it's applied, they come up with the score, and then they calculate your premium, and it's just a multiplication factor. If you owe $1 million in premium times 0.8, now you know you owe $800,000. If it's 1.2, now you owe 1.2 million. All right, so that EMR is very critical, and all contractors should know their EMRs, because a lot of times it's a lagging indicator. Typically speaking, they take 3 years of losses and they say, I'm going to give you a 1-year grace period and then I'm going to take your next 3 years of losses. And if those losses are below our estimate, then your number is going to start to drop down. All right? So, but that only applies to workers' compensation. And the overwhelming majority of cases' values are in general liability. This morning you talked about labor law claims and falls and fall from heights and all the rest of it. On average, those cases run between $1.5 million and $2 million per claim. And if you have too many of those cases, your general liability carrier is going to say, I don't want you anymore. I can't afford, you're not giving me enough premium to pay these type of losses. So when Joe referenced these MWBE contractors who didn't have a relationship with the market, they're going to have high GL rates already. And now, if they have to start using their own coverage and they have to start paying claims, those rates are going to go higher and higher and higher. And when they go to bid day on a non-wrap-up job, their insurance cost is more likely going to kick them out of the bidding because it's in with everything else. Everyone pays about the same for bricks and mortar, right? It's insurance costs and labor costs that typically change the difference in bidding. So that MWE contractor who can't afford to buy coverage at a certain rate, there's no way he's going to win a bid. So programs like the SCA, the MTA, the Port Authority, who don't require them to include insurance costs to bid, give them a huge opportunity to win work. But if these organizations aren't allowed to do wrap-ups, you're pretty much saying goodbye to that segment of the workforce. Did that help at all?
Yeah, I think so.
All right. Went on, Kendall.
No, I was with you. I hope the audience was too. Let's turn to a second aspect of safety, which is just the health safety programs get started and administered at work sites. And Tim, I wonder if you can say something about that. I mean, you've seen this both as a broker and as part of the construction industry.
You have multiple, on a typical job site, you have multiple different safety programs going on at one time. And the best projects, the best safety run projects are ones that combine them all. You'll have a general contractor, and a friend of mine here from Turner, Bob Yaden, they've put together one of the best safety programs out there. They do early morning talks with their subcontractors every morning to say, hey, this is what we're going to focus on today. We're going to focus on fall prevention. We're going to focus on eyewear. We're going to focus on the proper gloves to wear. All right, so those type of safety programs start from the owner because they ask the general contractor, I want to see your safety manual. I want to know not what you do on every other job. I want to know what are you going to do on my job to mitigate exposures and mitigate losses. And then that general contractor in his bidding to the subcontractor say, I want to see how you're going to handle this scope of work and how you're going to do it safely. So when you combine all of those together, you typically have your best chance to have a safe job.
Okay, so I'd like to turn to Lorraine here because the MTA is in an unusual situation where in some circumstances it can take the lead on safety. It's got to wrap. It's got to watch what's happening at the job site. It has extra funds to ensure that certain safety programs and processes are in place. And then yet it's very different in your non-wrap program. So I wonder if you could tell us a little bit about how that plays out and the difference between the two as you see it.
Sure. I'll talk about the wrap-up for a minute. We have, as I mentioned earlier, very specific safety programs that we put in place for the projects. We hire certified safety professionals, and these are also, we try to use people who have had experience on our prior wrap-ups and understand our properties, because doing construction on a railroad or on a subway or within our operation they present some unique risks. So we've been fortunate, I think, to have some people who have had prior experience on our projects. So that really helps a lot. We also have some resources through the insurance company as well. But it's typical sort of things that regular meetings, unannounced visits, safety, personal protective equipment, all of the usual things that are very specific to construction safety. On the bridge and tunnel side, or on projects where we don't have the wrap-up, we require the contractor to provide a safety plan, and usually it's the construction and engineering department within bridges and tunnels that will have some oversight. We have had some issues, though, with contractors where we've had some difficulty and had to bring in additional resources beyond what's been available, and that's an extra cost to us. That wasn't something that we expected. We expected the contractor to be able to be safe, but they weren't, in which case we had to bring additional resources to that. But clearly, we're able to have much more control, hence the owner-controlled insurance program, and we really pride ourselves in the amount of safety resources we put into those projects.
So I take it this is another reason that you prefer working with wraps?
Yes.
Yeah.
Yes.
Okay. Joe, do you see this any differently from Tim or Lorraine?
Well, one of the problems as an association that represents contractors throughout New York State and has to, when we look at laws that govern the entire state, we're not just looking at sophisticated owners like the City of New York and MTA and the SCA. But we've got the East Bloomfield School District or some other small entity out there that maybe does one project every 10 years. We are saddled in the state not only with procurement laws, but we have a number of fiefdoms throughout New York. I often marvel at when I go to other states. Maryland, for example, has a countywide school district system, and so because of that, you've got a level of sophistication because they build on a regular basis, as opposed to what we see throughout New York State. Now, with that said, it is not uncommon to see legislation in New York State every once in a while that will say this law applies to cities with a population over 1 million. Now, there's only one city in New York that has population over 1 million, and that's New York City. Now, Buffalo is trying to make a charge. They've got actually 5 tower cranes going on right now in Buffalo, so who knows? Maybe Buffalo will get back to that level. But it's one of the real conundrums that we have to deal with in New York is the broad expanse of the type of owners and the type of issues, and unfortunately everything kind of gets lumped into one. But again, my biggest concern is just in the procurement area.
Okay, I would point out that while there are a number of states that do not prohibit wraps at all in the public arena, others that have chosen to regulate have chosen a different basis for regulation, including simply size of project. Say a $50 million project or a $75 million project would be deemed to be large enough for a public entity to use a wrap. Larry, if the city of New York were to become broadly eligible to use wraps, could it supply the necessary program management like we've heard about here? I see you're rubbing your hands. I think you meant.
The answer is yes. You asked in preparation of this session, you asked about that, and my answer was, well, we haven't had to think concretely because of the prohibition, which of course we think is unwarranted. But thinking about that, if the skies would open, what we'd probably do is start with CCIPs, again, the distinction contractors controlled. In that situation, we might have a single large project, recognizing the utility for everybody, and we would either mandate or allow the general contractor to have a CSIP. In that situation, it would be the contractor, a turner or the like, that would handle, control the wrap-up, and it wouldn't handle or control it much differently than for a private developer. And so, if the skies would open, chances are we would do it that way from the start, for those projects for which wrap-ups are appropriate. Very large, concentrated projects. Conceivably, down the line, we would see the volume and the utility to moving towards the MTA model. But we needn't worry about that yet. Again, my perspective is the prohibition, and that prohibition essentially keeps us from developing the larger expertise, and certainly keeps us from the no-brainer of CSIPs.
Got it. Thanks. So let's turn to some other pros and cons of this prohibition, and let's go into a little more insurance detail too. Tim, can you tell us a little bit about what completed operations coverage is?
Sure. Completed operations coverage is an add-in coverage to your general liability policy that handles claims that arise after a project is completed. All right, so typically you're going to see that in a couple of different ways. You might see that in sidewalk accidents outside of a project you built, or somebody who trips and falls going down the stairs, and they say that because of the steep grading of the stairs, that's why they fell, not just because they were clumsy. And in that scenario, your completed operations would come in. In addition, it would come in a construction defect scenario. One classic example I had when I was at Turner, Turner built the original Madison Square Garden, the one that was built in the 60s. And about 5 years ago, there were 2 young ladies who were out having a good time, and it's 3 in the morning, and we're coming back to Penn Station, and one pushed another into the glass, panes at the Madison Square Garden, and the poor lady actually went through the pane, was severely injured, and lost a part of her leg. and they sued Turner, saying that it was built improperly in 1967. Now, in the state of New York, that's allowable because the state doesn't recognize something called a statute of repose that says if I bought a machine 10 years ago and I go to use it again, I can't sue Black & Decker because my snowblower didn't work 10 years later. Most states have that. New York doesn't recognize that. So in that case, we were actually brought into a claim and had to defend ourselves out of a case or something that was built 40 years ago. So completed operations is the coverage that steps in that matter, and it is extremely important here in the state of New York.
So, Joe, why does completed operations coverage present a particular problem, in your view, in connection with RAP programs?
Well, I think one of the particular problems is where contractors are doing little more than work within a RAP program. They don't have the insurance capacity, if you will, or history to fall back on for completed operations coverage for those long-term situations. Now, as Tim said, we don't have statute of limitations or statute of repose in New York. Now, most claims happen within 3 years, is standard knowledge, but they go beyond. Now, even a state like Minnesota that had a statute of limitations, the court basically reversed it within the decision on the collapse of the Route 35A bridge or whatever the bridge was that collapsed in Minneapolis, and they went back to that. So probably more so for subcontractors, and I don't generally argue on behalf of the subcontracting community. I have enough to do with generals, but they have a very large difficulty on statute of limitations, and they would like it to, or statute to, or complete operations coverage. They would like it to go for a long time, and have gone to the what was the Insurance Department, now Department of Financial Services, to look for relief in that regard, to require completed operations under OSIPs and CSIPs for, they first started out with forever, now they're, I think, at 15 years. I think standard, and Tim, you can probably answer this better than I, standard, what we see is 3 to 5 years is probably standard for completed operations coverage under an OSIP or CSIP.
Starting to go up now, more and more, 6 to 10.
6 to 10, I think SCA, Ross is 7, right? So there is some exposure out there. How much that exposure is, who knows? But the more a contractor is engaged in an OSIP or CSIP and not, without the insurance capacity outside of that, the more that risk goes up to where they can't afford or can't get the completed operations coverage for work that they've done outside of that.
But just to be clear, are you saying this problem is any different when public entities are using RAPs than when private entities, or is that?
No. I think it's the same from that standpoint. Although I suppose just from what I've seen, and Lorene, I don't know what your completed operations limits are. Probably for public policy reasons and other reasons, you might have more ability to see lengthier completed operations coverage in a public setting than in private, but that's just a guess.
We typically get 5 years, and that seems to have been okay. The good thing about having an owner-controlled insurance program where we buy the insurance is that if the need arises for us to try to get lengthier coverage, we can do that on our next program and make that one of the requirements when we purchase the insurance.
But do you see this problem?
No, we haven't seen it.
Okay.
No.
All right.
So far, 5 years has been, okay for us. So.
Okay. Turning to another aspect of RAPs, does the use of OSIPs by public entities have any effects, pro or con, on the hiring and use of women and minority-owned business enterprises, or the WMBEs? Joe, do you have thoughts
Well,
on that?
I think to some degree, I think it's a double-edged sword. I think Tim rightly says that it is a real positive entree into the marketplace, and I think unfortunately it limits the growth to if they focus so much on within RAP policies, RAP programs, without developing that bit outside. So I think it's. While on the one hand it presents a real positives for entry, I think on the other hand it may stifle growth down the road.
Would either of you like to add to that, Lorene or Tim?
I think having the program is a real advantage to for small minority-owned, women-owned businesses, absolutely. We just started a small business mentor program at the MTA a couple of years ago, and it's a program where basically small businesses are working with us under a contractor, and then eventually the idea is to help them in setting up their businesses so they can then go out and bid for additional work. So having the OSIP in place has allowed us to insure them for this period, and then when the program is over and they're ready to go out, they'll go into the market on their own. But yes, it's been very beneficial.
I would agree with Lorraine.
Yeah.
Essentially, it's a life's blood to these type of contractors because it allows them to be on an even playing field with their larger brethren. And it allows them to get work. And without it, they're just not getting that work.
Now, looking across the region or across the country, as I mentioned before, some states do have prohibitions on wrap insurance for public sector entities, and some don't. In fact, for those of you in the audience who might be curious about this, there is a material on the website for this program, and you'll see for Panel 4 we have a survey of 10 states, including several in this region, that will tell you what the laws are and who does not have this kind of prohibition. And I want to also note the great effort of my colleagues on the Committee of Insurance Law for putting together that survey and doing the research for that and writing it up. But Tim, your responsibilities at Willis and before that at Turner really covered a number of states in the region. I wonder, so you may have seen sort of something of this from state to state. What do you see a comparison there?
From what I've seen, no other state has the prohibitions that New York has. And unfortunately, no state needs wrap-ups allowed to all public sectors more than New York. On average, cases are at least 2 to 3 times, worth 2 to 3 times more in New York than they are elsewhere. And we have identified wrap-ups as the single best tool for an owner or a contractor to use to protect themselves. They're all subject to the labor laws. They're all subject to the vast amount of litigation out there, yet to take away that tool from the people who need it the most is actually crazy. What I would like to see is if you're not going to allow some of these public agencies to use that, you should then take away the ability to have labor law claims filed against them. Anyone in favor of that? There you go.
I'd give you both.
I'm assuming Mr. Fernandez left. Is that it?
All right, so let's just talk a little bit about prior efforts to get the 2504 liberalized. Lorraine, do you have some experience with that or anything to say?
Yes, we were. I think it's been probably 3 or 4 years now since we were attempting to get to further amend or add additional exclusions for the City of New York. We were working with the city, and also for bridges and tunnels. And then we would also be able to do projects around bus depots because that's excluded from the law currently. So, yeah, we absolutely, if when the opportunity presents itself again, we will continue to lobby to get all of our agencies under a wrap-up.
Tim, did you have some experience with these attempts in the past, or
with trying to
liberalize 2504?
Yes, yeah, unfortunately, I think the state has kind of fallen on deaf ears to a lot of it.
Yeah.
I'll give you a perfect example. There are a lot of infrastructure projects going on right now. One being the Goethals Bridge. The Goethals Bridge is going to be $1 billion job, and it's being done under a traditionally insured program. There is going to be massive amounts of cross litigation. The general contractor or the joint venture on that job is going to have to spend an inordinate amount of time checking subcontractors' insurance policies and the rest of it. It's foolish, but that's the prohibition in effect.
Well, our time is drawing to a close, so I'd like to give everyone on the panel a chance to add some final comments or thoughts about this. Let's start with Joe Hogan.
Well, it's an interesting thing, and I heard a lot about with the OSIPs and CSIPs the idea of cost, and I will tell you from my standpoint, and historically we have opposed it, as you kind of gathered, but I think the biggest reason for it these days is not cost, but because of 240, it's the lack of availability. It's the gaps that we see in the coverage. The Scaffold Law the 240 exclusions. We've seen exclusions on work over 3 stories, and the ability of a contractor to, general contractor and owner to review that, particularly general contractors on a building job with a number of subcontractors, is very, very difficult. And so one of the things, and it's in your packet, there's a sample form or a draft form that will go live in June, I believe, Accord 855. It's something that we negotiated very hard for. We had to fight back some things in the legislature and then begin working with the professional insurance agents in developing this. And it's a tool for contractors and owners to use to really review what it is in their insurance program. But it's ironic when I hear this morning about the union versus non-union issue and the whole bit, and again, I'm statewide. It's an odd irony that indeed when you look at 240 and the push because of 240, as Tim indicates, the need for OSIPs and CSIPs, indeed that works against the idea of union versus non-union. Yes, is it positive for entry firms? Absolutely. But it's kind of ironic to watch that and to watch how the marketplace plays out because of scaffold law in New York State. And OSIPs and CSIPs are just one of them. But in a perfect world, we would change 240. We would give public owners a mature ability to procure properly and engage, for example, in CM at risk, and in that CM at risk procurement require the construction manager to engage a CSIP. That, in my mind, would be a perfect world on certain projects. Unfortunately, in New York State, we are unique in too many ways.
Tim, what are your thoughts?
Wow, I don't think I have enough time. My thoughts, I'll just end simply with this. Everyone here needs to understand, currently we are in a very significant insurance crisis. If the cost of concrete doubled in the past year, you'd see it and read about it and hear about it on the news every day. If the cost of gasoline doubled in a year, we're looking at doubling or tripling that. You have insurance carriers fleeing the New York market. I'm not sure if you heard about that this morning from the plaintiff side, but no one's making money insuring construction in New York because of a couple of things. You have the labor law.
Well, we heard dispute about that. So,
and then there's massive amounts of workers' comp reform that needs to be done. So unless something happens, you're going to see a significant spike, a continued significant spike in insurance.
Larry, what's the takeaway for you?
Well, I'll be brief. There's almost a consensus, hopefully, in the audience, that at least some segment of the public entities which are now arbitrarily, to our mind, barred from any kind of wrap-up be permitted. The rest of MTA, the city of New York, or you can pick the size of project. If there is any concern that we want to save the Herkimer counties from themselves, you can draft around that. But I frankly don't see much of a reason, especially given the current circumstances, for us to be prohibited from doing it.
Mm-hmm. And then, Lorraine, I will let you wrap this up.
Thanks. Well, I mean, I think if we can take anything away, I think I'd like to believe that the MTA's programs over these many years, these almost 30 years, I think is proof that wrap-ups can work for a public entity, and how well they can work, because doing construction while we are operating a very, very busy transportation organization gives us the kind of insurance limits that we need. We know we have no gaps in coverage. Allows us to put resources into safety, which is extremely important, not just the safety of the contractors and the men and women that are working, but actually the riding public and our own employees as well. But it also, I think, has been proof that as we've gone through these difficult times, like this current crisis with the labor law, that we have our program in place, and it's helping us get through that, at least for the agencies that we can cover in our wrap-up. The other bridges and tunnels are presenting challenges for us. So.
That's great, thank you.
Okay.
Now, do we have time for questions?
People want to stay, yes, we're going a little bit over.
Okay, we've gone past the 2:30 time, but those are
sorry.
questions I'd be glad to take for a few minutes. Yes.
You know, I understood his going to say, and maybe I heard wrong, that some of the contractors they use can get, there's an exclusion for coverage of
Oops,
Section
okay.
240 of the labor law.
Yeah, exactly, so,
And-
yes.
And yet, even so, that insurance is expensive, it comes with a big deductible.
Right.
Now, if that is the case, you know, and I'm changing what I might have believed as of this morning, if that is the case, how can the crisis you're talking about be blamed simply on Section 240 of the labor law if the insurance company, even with it excluded, is demanding a high deductible and a high rate?
Yeah, let me start off, and I'll let Tim follow up on that. Part of it is basic laws of supply and demand. Right? As insurers flee the market and it becomes difficult to get insurance, you know, people keep asking, well, if we change the law tomorrow, our insurance rate's going to go down. Well, if you look at the way loss costs are calculated in the whole bit, it may be a tail to that. But basic laws of supply and demand, if you've got 3 suppliers of a product, there's going to be a price base on it. If you have 1, there's going to be a price base on it. If there's 10, laws of supply and demand will have some impact. It's not purely, I mean, I know folks will say loss cost and the whole bit. It's not purely a loss cost situation. There are laws of supply and demand. There's competitive factors in what the costs are. So as contractors are going out and they're buying other insurance and they're procuring it at higher rates and they're getting inferior products, and I will tell you, I had a conversation with a roofing insurer recently. Made my hair curl because he said every roofer I insure has Swiss cheese for coverage. Wow, what a risk. So there's obviously there's a cost for that insurance, but that cost also then is to the contractor himself, the general contractor who has to bear that risk, and the owner has to bear that risk of inferior insurance. And we didn't even go into hammer clauses, but that's a whole different conversation.
Just to dovetail off of my colleague here, essentially, it's cause and effect. You've had such a spike in these labor law cases values that the market has done 2 things. Carriers have left the market, or some that have remained have tried to manuscript policies that get them away from that exposure. So it's not something that's been around a while, it's something that's just happening now. And it is not prevalent yet, but you're beginning to see it. And oftentimes these subcontractors or contractors who have this coverage have no idea they don't have it. And it's not until they have a claim and they try to go invoke coverage that they find out there was an exclusion.
Yes, hi.
I'm so disappointed panel 2 is not here to listen to you all, or at least confront you, because they said a lot of things about insurance.
Yeah, we won't go into that.
Oh, man, I really missed
That was
it.
brutal.
Did anyone tape it?
Yeah, it's been taped. It's been
Will
taped.
Will it be on YouTube?
It is.
Oh, excellent. Okay.
It'll be on the City Bar website.
I'm getting revved up.
So, just gotta say, Lorraine, I want to give a plug. 3 things I'm very happy about in my 10 years in the legislature. 1 is creating that MWB mentoring program at the MTA. My boss actually sponsored the legislation, and I worked on drafting it. So.
Good. It's a great program.
Yeah.
But to that, this is the first time I've heard publicly someone say that the OSIP, and there's a bonding part to it, but the OSIP is really helpful to big MWBEs once they leave the mentoring program. It's been used as propaganda from those who would want the comparative negligence or the repeal of 240, 241 that MWBEs are suffering. Do you think that, from your experience at the MTA, that is a legitimate concern, argument, that not having OSIP or that the insurance industry as is, the availability or lack thereof of the product is really a hindrance to the MWBE's growing in construction?
Well, I think without the program right now, it would be difficult for them to, for example, bid on a bridge and tunnel project because our requirements are very high. And so with what's happening in the market now, I don't know that they would be able to meet those requirements. It depends on the project. Let me make that we don't require $5 million in general liability limits in every project or $10 million. It just depends on what the project itself is. If it is a large project and the MWBE is going to serve as a subcontractor, then those requirements would be passed down from the contractor to them. So yes, it would be a challenge for them to meet the requirements on a non-OSIP project. Our hope and expectation is that when they come in and do work through our program and are able to get coverage through the OSIP, that once their company gets up and running and they also get the benefit of the safety program and the safety training, that they will be able to then go out if the market conditions can improve.
Just one thing, just to be clear, we really didn't talk about this, but just as the SCA experience indicates, and I'll be real curious to see what happens with the MTA next year, because of a variety of things, all related, in my view, to 240, but that I suppose folks will debate. As difficult as it is for contractors to get regular general liability coverage, it's becoming more and more difficult for contractors to get CSIPs as well. And at the same time, OSIPs are becoming harder and harder. The limits, I don't know, Tim, what you're seeing, I'm hearing instead of, what may in the past have been 2 million, 4 million limits, we're hearing 5 million, 10 million on CSIPs. So it's not a panacea to the issue of the insurance, and I think that the SCA may be a canary in the coal mine, as it were.
You may have thrown out some numbers. What do you mean? What do those numbers mean? The 2 million, 4 million, 5 million, 10 million?
Tim's probably more expert, can talk more eloquently than I am.
Okay, I don't know about that, but essentially what he's talking about are what's known in the industry as attachment points, all right? The market that's most affected by this current insurance crisis is the excess liability market. All right, excess carriers underwrite programs with the expectation that they would rarely ever have to pay a claim. So originally, a contractor would have $1 million per claim, $2 million aggregate primary policy, and then you would have excess over top of that. And the excess markets started to get hit with far too many claims. So they raised that attachment point to 2 million and 4 million, and they were still getting hit. So now to do a CSIP, where a carrier is going to take on all of these exposures and all of these contractors, the excess market is saying, I'm not touching it until it hits 5 million per claim, 10 million ag. And that's what he's talking about. So it's getting harder and harder to go to market and buy this. And in addition, subcontractors can't buy a CSIP. It's only for general contractors. And typically, you need to have about $100 million in construction volume a year for the market to be interested in you. So going back to your earlier comment to Lorene, I think two things are greatly helping the MWBE market. Wrap-ups, and then these similar programs for bonding, where a general contractor can bond all of the subcontractors. So in that scenario, a MWBE sub doesn't have to bring bonding, and he doesn't have to bring insurance to a bid. That's probably their best, option or best opportunity to win a job.
Let's take one more question. I'll take one in that far corner back there. Thank you.
I didn't hear too much about the politics this morning. Maybe I don't hear it today so far, but what is the opposition to amending the city law and the MTA law to allow those agencies and other public agencies to require OSIPs and CSIPs? Who's opposing it and why are they opposing it?
A lot of the smaller to medium-sized brokers are opposing it.
The brokers.
Yeah, because they carry the traditional coverage for these subcontractors, and they would like to be able to keep renewing that and keep getting revenue from it. And they're not really in the market to do wrap-ups.
And I will say, for full disclosure, we have opposed it, but again, it's looking at the statewide issues of it. And again, our main concern is the procurement issues and the impact there. But we certainly didn't oppose it with the SCA, and I don't think we would oppose it with the MTA in those circumstances. Because there is some value. I mean, and how that plays out. I'm not, to be honest with you, I'm very, very dubious about the bonding issue. Subcontractors are not required to be bonded. General contractors are on public work, Section 137 of state finance law. And so how that plays out with regard to who's who's covering whom, and the nature of bonding is not the same as insurance. And there's personal indemnity. There are a lot of things that go into a bond that how an owner could possibly do something like that and take on that personal indemnity. When a contractor signs on a bond, they're signing on and risking their house, their property. Everything is on the roll of the dice every time they bid a job and they have to put a bond up. And that's a tremendous amount of risk. And how an owner would do that, I have no idea.
Owners don't do that. It's generally a general contractor, and those programs don't have personal indemnity. Right. They do turn around and try to sue a contractor who defaults on their obligation in a contract, but that's typically what happens.
Well, I'm going to bring it to a close at this point, and those of you who'd like to come up and speak to the panel privately afterwards are welcome to. So thank you, Joe Hogan, Tim Walker, Larry Martin, Lorraine Coyne.